All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning and welcome everyone to a virtual oral argument before the District of Columbia Court of Appeals. Because of the pandemic, our court has had to make some changes in the way that we do our work. And one of those changes is having oral arguments remotely. We live stream these arguments on YouTube, and a link to the argument can be found on the court's website. Our staff has worked very hard with the litigants and the judges to try and make sure that we don't encounter any technical problems during the argument, but problems may arise nonetheless, and if they do, we ask for your patience. We have 3 cases on our calendar today. We'd like counsel to introduce themselves for the record before they begin the argument, and for appellant's counsel to tell us how much time they would like to reserve for oral argument. So we'll first hear case number 19-CO-160, Cephas Hollis versus the United States. Ms. Persico.
Yes, good morning, Your Honors. Deborah Persico for the appellant Cephas Hollis. I'd like to reserve 2 minutes for rebuttal. So the appellant's argument is essentially that the trial court erred in denying his 23-110 motion and in finding that it would not have granted a severance motion even had the attorney filed one. So our position is that there's no support in the record for the court's ruling that the 2 carjacking incidents were committed in furtherance of the conspiracy to commit first-degree theft. And for that matter, the carjackings were not similar to each other or to the conspiracy. They were not connected. They were not mutually admissible, and they certainly were not kept separate and distinct. So with respect to the court's finding on the conspiracy, there are 2 key portions of the record that I think this court needs to focus on. And the first portion is the indictment itself. The conspiracy account, which, you know, we all know conspiracy is an agreement. In that conspiracy count, there is not one object, not one overt act, not one goal that alleges any violent conduct whatsoever. It is strictly a conspiracy to commit a property crime, to steal cars. And the second portion of the record is the testimony of the government's star witness, the co-defendant, Kyrie Waters. And his testimony is particularly important on this issue because he tells you, makes it perfectly clear that there was no agreement to commit any violent conduct.
Can I ask you, I just want to make sure I understand your in particular, the first of your points. So, but really the combination of the 2. So if person A and person B agree to steal cars and to work together to do so, and let's say they actually even, I think maybe better than the facts in your case, let's say that B says, by the way, I'm a non-violent person. I'm not really signing up for any violent car theft, so don't count me in for any of that. And A says, understood, that's the scope. All we're going to be doing is, you know, stealing cars without using violence. And they steal 3 or 4, and then in number 5, they're working together to steal the car, and, you know, the owner comes up and takes issue with them stealing the car, and, you know, person A ends up shoving the owner and kicking the owner. So there was some assaultive conduct involved in that. Are you saying that theft of the car is not part of the conspiracy or in furtherance of the conspiracy, because as things developed, some violence arose during it?
Well, there's two separate charges here. I mean, there's theft of the vehicle, and then there's carjacking, which is a violent taking by force or violence of the vehicle. And in order for the carjacking to be in furtherance of that theft conspiracy, there's got to be the violence has to be a reasonably foreseeable consequence.
Well, that's where I was going. I mean, that's part of what I'm asking you, because I think one could arguably reasonably foresee that if you steal people's cars, even if you hope that that won't be violent, because you're going to look at cars where nobody's around, you're running the risk for sure that they might see you do it and they might take issue and you might need to use force. So at least arguably, it is reasonably foreseeable that force would end up being have to be used in furtherance of your objective to steal cars if the owner takes issue.
Okay, but I disagree with you in this particular case, especially because what you have here is you have the co-defendant saying, we purposely avoided occupied cars. In fact, when we saw that someone occupied a car, we drove away. We waited.
Right.
So
can I just say that, I mean, you could have two reasons why you're avoiding occupied cars. One is because you're kind of the Mahatma Gandhi of car thefts, and you like stealing cars, but you're really very pacifist.
Mhm.
The other could be, however, that's easier. It's less risky. You're less likely to be caught. If you have to use violence, it could go badly for you or well for you. So it could be kind of a prudent way of implementing a plan to steal that isn't really reflective of a refusal to use violence, and instead just like that was how we were kind of choosing to do it. We didn't really disavow violence. It's just that we weren't looking for it.
But what you're doing is you're speculating on what these two men were thinking. What we know from the record is that they purposely avoided occupied cars. They drove away when they saw someone.
Well, actually, that's not. I thought the carjacking didn't fit that model.
No, it did. The carjacking, they see a car. The Mr. Gathers was a newspaper delivery person. They waited until he left to go deliver the papers, and according to the testimony, the appellants had told Mr. Waters, usually these delivery people leave the keys in the car. So, we'll wait till he gets out of the car, he goes to deliver the papers, and that's when, according to the evidence, Mr. Hollis makes his move, he goes in the car. So again, the purpose. I mean, you don't. You're speculating as to the reason when.
No, actually, I think there's just no evidence one way or another whether they were their agreement was. I mean, there's no evidence that they explicitly disavowed violence. That there was this is nonviolent car theft. Is there any evidence that was an express part of their agreement?
Well, they don't have to say that.
Well, I'm just asking you a question about the. I'm just asking you a question about the evidence.
No. I mean, there's no testimony. We're not going to kill anyone. We're not going to assault anyone. But from what they did from what Waters did testify, that was exactly what the intention was, because they did it several times. They saw someone in one car, they drove away. They thought a car was unoccupied, and when they got closer, they saw that it was occupied, they drove away. With Mr. Gathers, they waited until he got out. So what the mutual agreement was.
Can I ask you, so we're right now, the discussion, which is, I think, focused in significant part on joinder, though it may be relevant also to severance, has been about the implication of the conspiracy count. But on joinder, at least, the argument is that, leave aside conspiracy to steal vehicles and stealing vehicles and carjacking are all of a same or similar character. And that's kind of just the government's view is you can kind of see that just from if you don't need to know any more about the charges. If you know those facts, you're trying to figure out whether you can join under Rule 8A, conspiracy to steal vehicles, stealing vehicles, and carjacking. they're just sufficiently similar that you don't need to know more. You disagree with that, I gather.
Yes, I totally disagree with that because in the Roper case, which I cite with the government, which the government takes issue with, in the Roper case, they considered both the indictment and the factual similarities. And here you cannot simply say that, well, the final outcome was a car was stolen. You can't just look at the final outcome. You have to compare the, well, first of all, if you look at the conspiracy count and the carjacking, indictment-wise, they are completely not the same. One requires violent conduct, the other one is simply a property crime. As far as the two carjackings are concerned, whether they are similar, again, what I am saying is that based on Roper, based on Sweet, which says that the common elements within the indictment is only one factor to consider.
Can I ask you though, in terms of case law though, I understand the general principles you want to extract from Roper and from Sweet, but do you have cases of ours that look at offenses like, let's say, like theft and carjacking and say, no, they're not of a similar character in any circumstances? I mean, what's your best case for looking at like forms of property crime and saying these are both property crimes, but they're different either because there are additional elements in one or because in their circumstances they are different, so they are not properly joined under 8A. Could you point us to some case that has gone that route?
I'm sorry, no, I don't have specific theft/carjacking cases.
Or any cases, or any cases that you think support your view about how much similarity is required, either in terms of the elements or factually, if you get further into the weeds of a particular case. Like, what's your best case that you think is somewhat analogous to this, where we've said, well, there's some overlapping elements between charge A and charge B, but they're not of the same or similar character, and therefore they weren't properly joined? Like, what's the closest case do you get in outcome to the circumstances here?
Well, I think the cases are kind of I can point to the opposite in cases. For example, if you're looking at whether two charges I mean, and I don't know whether we're talking right now about similar or about connected.
My questions were about same or similar character.
Same or similar, and are you speaking about the conspiracy as opposed to the carjackings, or the two carjackings as, you know, with?
I'm really speaking about all three of so conspiracy to steal vehicles, carjacking 1, carjacking 2.
Okay.
All three.
So as with respect to the conspiracy and the carjackings, that's the initial argument that we're saying, that those have to be tied by a mutual agreement.
Well, no, I guess, see, the trial court's view, which your original argument was about, was that the later charges are in furtherance of the conspiracy. That's a different inquiry than the question of whether, either in the abstract or more concretely, conspiracy to steal vehicles is the same or similar in character to carjacking.
So all I'm saying with respect to that, whether they're same or similar, the carjackings with each other, are they the same or the similar?
No. Just to be clear, though, I thought you were saying the following.
Okay,
I'm asking questions that are about, for example, is conspiracy to steal a vehicle the same or similar character for purposes of Rule 8A as carjacking? If that's the question. I understand your position. I'm just saying, if that's
okay.
I took you to, in part, say the only way they could be in same or similar character is if the carjacking is in furtherance of the conspiracy, and that seems to me not obviously correct. I mean, they could be. I mean, again, for example, you would agree that if there had been, you know, let's say that the two folks here had conspired to steal a bunch of cars and had stolen a bunch of cars. And then like a month later, your client only, without, they had decided they're no longer acting together, and your client only had gone and stolen a car in the same way. Would you say they're not joinable because the last of those thefts is not in furtherance of the conspiracy, because there is no conspiracy anymore, that had already been terminated?
Well, yeah, I would say it's not in furtherance of the conspiracy.
I understand that. I'm asking whether the theft is same or similar as the conspiracy to steal.
Is it just simply theft?
Yes,
Simply theft, not a violent carjacking.
correct.
I would say those are far more similar, but in this situation, you don't have similar crimes.
Well, I understand.
A carjacking and a theft.
Maybe it would be good. I know we spent a lot of time on the joinder part of your argument.
Mhm.
You also have a severance set of issues, so it might be good
Sure.
to move over to those.
Okay. Oh, you want me to move over first? Okay, fine. So same thing with mutually admissible crimes. So here you absolutely have to do that balancing act of similarities versus dissimilarities to determine whether they're mutually admissible. And if there are insufficient similarities to create a reasonable probability that the same defendant committed both crimes, then they are not mutually admissible.
Well, the government, I thought, had a different theory of mutual admissibility in part, which is, let's say, for example, the admissibility of the second carjacking in a trial of the conspiracy to steal. I thought one aspect of the government's argument was, if the government is trying to prove that there was a conspiratorial agreement between your client and Mr. Waters, if I recall correctly, to steal cars, evidence that a week after, so let's say there was a conspiracy, evidence that a week later, even if it wasn't part of the conspiracy, the two of them acted in concert, with one of them at the end providing aid to the other in actually stealing a car, is corroborative of the idea that they are, or had a prior conspiratorial agreement on the same general topic. Do you agree that that wouldn't require that theory doesn't require similarity, or you think even that theory requires similarity?
Well, I think what you have to look to is whether there is a substantial portion of the proof of one crime that would logically be relevant to the second crime. And so what I'm saying here is, let's just take the two carjackings and leave the conspiracy out for a minute, which I think is completely dissimilar to anything that happened in the Gathers and the Mr. Shue incident. So the government cites Federo. In the Federo case, they say that one crime has to reflect a substantial portion of proof of the other. You do not need anything, the government does not need anything from the Gathers incident to prove the Shue incident. And why is that? Because those two crimes are so factually dissimilar that one crime does not prove the other crime. And I think you're possibly getting stuck on this idea of the theft of the car. And what I'm saying is, you can't simply look at somebody wanted to steal cars. You have to look at the whole picture. You have to look at the nature of the crime. And between those two cases, just Gathers and Shue, there's nothing in the Gathers incident that substantially is needed to substantially prove the Shue incident, because they are so dissimilar.
I know you're over time, but
sorry.
It's a component of your opponent's argument that really it doesn't matter whether you're a competent lawyer should have filed a motion to either an objection to joinder under Rule 8 or a request for severance under Rule 14, because the evidence here was so overwhelming that there's just no reasonable probability that even in separate trials the outcome would have been different. And can I add one preliminary question? Are you thinking that a good lawyer would have asked for 3 trials here? One
Yes.
for conspiracy to steal, one for carjacking
Yes.
1, and
I
one
think-
for carjacking 2?
Yes, I think they were all dissimilar from each other. So they should have had a conspiracy, a Gathers trial, and a Shue trial.
And
Yes.
do you want to just take a minute to address your opponent's argument that really just doesn't matter because the evidence here was overwhelming?
Well, they're saying that because the only thing they're quoting is their side of the testimony. So if you look at the cross-examination, the only person who identified my client was Kyrie Waters. Look at his cross-examination. He was substantially impeached. Impeached particularly, not just with the fact that he had previously stolen cars on his own without Mr. Hollis, the fact that he had bipolar disorder and was not on any medication, but especially the fact he admitted that he was told that if he helped convict Mr. Hollis on these crimes, that the government would seek a lower sentence for him and that possibly he could avoid a mandatory minimum sentence. So, their case is not as strong as they make it sound in their brief, because all they're citing in their brief is the direct testimony. And if you look at in the Tornero case, this is where you can compare. In the Tornero case, the claim was, the defendant's argument, his defense was that the complainants had fabricated these sexual assault. But this court pointed out that there was no motive in the record for such a fabrication, and therefore the government had a strong case. In Mr. Hollis's case, there was large a motive for fabricating and identifying Mr. Hollis as the one who beat Mr. Gathers and participated in the shoe incident. So those are two of the reasons. And then also, you have to look at the quality, the nature of these crimes also, which made it particularly prejudicial to Mr. Hollis. You have the shoe incident, which by any account was, a depraved incident, we would all probably say. You can't compare that with what happened in the Gathers incident and think that there was no danger that the jury didn't infer guilt from what happened to Mr. Shue onto the Gathers incident, or even vice versa. They're looking at violence in one case and extreme violence in a second case under totally different circumstances. And so our argument is the government's case is not as strong as they claim it is. And secondly, because of the nature of these offenses, there is a danger that the jury may have inferred guilt on all of these counts.
Thank you, Ms. Prisco. We're going to turn to Mr. Hahn at this point, and we will give you a couple of minutes for rebuttal when we hear from the government.
Okay, thank you.
Thank you, Your Honor, and may it please the court, Brian Hahn for appellee of the United States. The trial court in this case did not err in denying appellant's 23-110 motion, finding that appellants, even if trial counsel had filed a Rule 8 motion for misjoinder or a Rule 14 severance motion, that neither of those motions would have been granted. I want to start with the Rule 8 joinder issue and talk about the fact that all of the offenses in the indictment were properly joined because they were, as Judge McLeese has been talking about, of the same or similar character. And this court's cases, starting, I think, with Weinstock and continuing in both Thomas and Gooch, say, look, we look at the indictment and the elements of the offenses and the general purpose of these crimes in order to tell whether or not they are the same or similar character. And this conspiracy to commit theft, along with 2 carjackings, which, carjacking is theft of a car from a person through violence, both of those, all of those are of the same or similar character. And I'd point the court.
Can I ask you, well, first of all, I just to be a quibbler, there were a bunch of other charges hanging off the carjackings that were assaults and other things that you wouldn't say were necessarily the same or similar character, right? So is that right?
Yeah. Yes, and I think that the assault charges for the carjackings themselves are, they're properly joined to, I don't think Pelham is arguing that they're not properly joined because they're part of the same incident.
Understood. You said all of them were the same or similar, all the charges, and that seemed a bit broad.
Fair
but
enough.
If you're talking about the sort of the 3 transactions, and there's conspiracy to steal vehicles, that's alleged in the indictment, and then there's stealing of, then there's carjacking 1 and carjacking 2. And if you take the lead charge in each one of those 3 clumps of offenses, what case would you point us to that you think is factually is a funny term here, but circumstantially most similar in terms of, say, the question of whether is theft and very aggravated form, vehicle theft or conspiracy for vehicle theft and a pretty aggravated form of vehicle theft should be viewed as the same or similar character for Rule 8A. I mean, what kind of case, what cases do you point us to that tell us kind of by elements, for example, what degree of similarity is enough and what degree is not?
Yeah, so I'd point the court to Gooch, and this is 609 A second 259. In Gooch, what happens is that there is a robbery charge, and then there is a separate independent UUV charge. And the court reviews this under Rule 8A, looks at whether or not those crimes are the same or similar character, and concludes that they are. And that's because both robbery and UUV are crimes against the owner's right of possession. And in that case, there's separate, the robbery wasn't even of a car, which is why it wasn't carjacking. And so because they had common elements, of improper use of someone else's property.
So you would say, for example, shoplifting and bank robbery are of the same or similar character for purposes of Rule 8A?
I think I would, Your Honor. I think I would say that those are of the same or similar character because they're both offenses against property rights. Now, whether or not, that results in a Rule 14 motion for severance, for example, because there's prejudice between those two crimes, is a different question. And
are you similarly broad? So you would say that like the most minor offensive touching and, aggravated murder through torture are of the same or similar character because they're both assaultive. I mean, it's really, you clump crimes into very broad categories and by elements, and that's all you need to know.
Yeah, I think that's right, Your Honor, at least for Rule 8 and its joinder or proper joinder. And again, because Rule 8 alleges a defect in the indictment. It says that the indictment is wrong for some reason because it clumps these crimes together. And I think that because looking at the general nature of the crimes tells you whether or not they are the same or similar character.
Can you help me a little bit with the general topic of, you said it earlier today and you say in your brief that we look to the indictment to figure out whether offenses are of the same or similar character. And we do have cases that say that, but then we also have cases that say, and at times in your brief, you seem to also kind of descend into, what more do we know besides the indictment, beside what's alleged in the indictment about additional circumstances. So I find a little, and so we have cases that will say sometimes we look outside the indictment. So I'm a little unsure. Do you understand our cases to be we never look at anything other than the indictment? Or do you think sometimes we look at more than the indictment? And if you think the latter, do you have any thoughts about when we do or when we don't?
Your Honor, I think that it's the difference between the clauses of Rule 8A. So Rule 8A, the same or similar character, I think that is mostly limited. I think it's just limited to what the indictment says. I think the test for example, connected together is whether or not there's a substantial overlap of evidence or substantial evidence of one crime is required is proof of another crime. And that test implies that you need to look at the actual proof in the case. And so for that, I think that the court has looked at the proof of the evidence that's come out of trial because that's sort of what the test requires. And it's hard to tell.
And is that reflected? I mean, do you think our cases reflect that kind of bifurcated theory about when we look to the outside the indictment and when we limit ourselves to the indictment, or is that kind of your theory not articulated in our cases about how to make sense of our cases?
I think that the specific when to look outside and when to look at the indictment articulation that I've just said is never specifically articulated in the cases. I do think that that's what the analysis actually does in almost all the cases. And I would like to point out that in Roper, which appellant's counsel talked about earlier today, in the section that talks about the facts of the offenses, it both is responding to the government's argument relying on the facts of the offenses in that case, but also there's a footnote within that paragraph that says, and usually we look at just the indictment when we decide this issue. So I'm not sure that Roper stands for the proposition that the court looks at the facts of the cases, of the offenses themselves, in order to determine whether or not the crimes are of a same or similar character.
So, Mr. Hahn, are you arguing that the fact that Ms. Persico is asking us to look beyond the indictment and look at the facts of, or actually she's not asking us to look beyond the indictment. She's saying basically carjacking and theft, not similar. Your argument is we've always looked at those as similar because they're both taking a property and in this case, a vehicle, and that's enough for joinder purposes. Severance, there's more, but joinder, because of the presumption, that's appropriate. It's both taking property and in fact the car. Why would we not look at the issue of violence versus passivity in the taking of the vehicles, and wonder, do you have a case where we have a sexual assault and a regular assault, which, for example, sexual assault and a regular assault, where we have found that severance was, or joinder, I'm sorry, staying with Rule 8, that joinder was appropriate?
So I don't have a case about sexual assault and assault, but I do think that Gooch is still closer than that, because Gooch says, again, that robbery and UUV are properly joined. And robbery, of course, requires force or violence, whereas UUV isn't even theft, right? UUV is the use of a car without permission.
If I understand your position in response to Judge Washington's hypothetical, if a defendant is charged in count 1 with getting into a brawl in a bar and punching somebody, and in count 2 with first degree sexual abuse for forcibly raping somebody, completely unrelated, several weeks apart, you would say properly joined under Rule 8A. Now there'd be a question about whether Rule 14 questions, but you think they're properly joined under Rule 8A?
I do, Your Honor. And and even if the court disagrees with that, that particular example, I think that's not what this case is in particular.
Sure.
If there aren't any more questions on the Rule 8 issue, I do want to move on to the Rule 14 severance issue. And I think that both the Rule 14 motion, if trial counsel had filed it, would have been denied, both because the evidence of the offenses was mutually admissible, and because the crimes were not, the evidence, the crimes were distinct such that the evidence wouldn't have been amalgamated by the jury to convict appellant of one crime based on evidence of another crime.
I gotta say, I don't really understand. It seems to me very difficult that both those things could be true ever. And although our cases sometimes contemplate that, I don't really follow it. If you're saying the offenses are mutually admissible, so logically evidence of one is very relevant in figuring out whether the defendant committed the other. And then to say, oh, but the jury wouldn't have amalgamated the two crimes because they're really separate and distinct, those seem to me logically incompatible positions.
And I think that I think there is tension between them. I will note that the court in Cox said that they're not mutually exclusive. So at least this court.
I get that we've said that. I'd love to have you explain to me, particularly in a case like this, how that could be. How they both could be true.
I think that I think that there are proper ways to present evidence when the evidence is mutually admissible.
That spins out. I noticed the way there are a variety of formulations of the second line of thought, not mutual admissibility, but kind of separate and distinct. One of them has to do with the logical connection between them, whether the jury would amalgamate them or not based on kind of how logically distinct the crimes are. Others focus on the way the matter was handled at trial, in fact. And when you stated it a minute ago, you were focused more on the logical relation between the two crimes. If we're shifting over to how it was handled here, in fact, the government's closing argument could not have more directly told the jury to amalgamate them. The jury, I mean, the closing argument is at several points, a key theme of it is consider all of this together. When you consider all of it together, you will see that the defendant is guilty here. So, I mean, the government couldn't have been more explicit in trying to persuade the jury to amalgamate. So I am puzzled about the applicability in this case of the theory that don't worry about joint trial. The evidence was presented so distinctly and is so logically distinct that a jury would never have considered kind of using them, interlineating them.
So I think that all of the factors go together in determining whether or not the jury there was that danger of that prejudice, right? So the fact that the incidents are logically distinct is one of the factors.
Maybe you're saying that's a factor in the abstract, but I thought your argument is they are not logically distinct. They are mutually admissible. They are logically highly probative of each other in this case.
And the government told the jury, don't distinguish them. They are logically connected. Consider them all together.
So I think I disagree with the court's reading of the closing that at every point or at large swaths of the closing encouraged the jury to think about them together. I think there's one point on page 89 of the November 9th transcript that the prosecutor says, the evidence for the two crimes reinforces one another. But I think what happens there is...
Well, I don't have the transcript ready to hand. I could pull it up, but I thought there were multiple places. I mean, you're right about the one reference you make, but aren't there multiple places where the prosecutor says, consider all of this evidence together, and when you consider it all together, this is what you will conclude?
So at the end of both the closing argument and the rebuttal argument, the prosecutor says, consider all the evidence together and find appellant guilty. And I think that this is a summation. This is the closing argument where the prosecutor says, look at all the evidence and find the appellant guilty. I don't think that that's
well, in
an
a case where you're
invitation
trying,
to the
if you're actually trying to tell the jury these are two completely distinct or three completely distinct sets of charges and keep them separate, I actually think you would close and you present your evidence quite differently. And you would say, like in the hypothetical where you had a beer brawl and you had, a first degree sexual assault, if you're actually allowed to try those together, instead of saying at the end, consider all of this together and you'll see the defendant is guilty of all the charges, that would be the opposite of what you should be doing if you were trying to say that that was tried separately and distinctly. I thought what you would be saying is, look, there are two different charges here. They're completely, they're not logically related. They have nothing to do with each other. This was tried together for convenience. Here is, I'm going to tell you the evidence of the first. I'm going to explain to you why the defendant is guilty of the first. Then I'm going to done with that. And then I'm going to move on to the second. I'm going to tell you the evidence for the second. I'm going to tell you why the defendant is guilty. And you would never, if you were actually trying to keep the jury from amalgamating them, you would do the opposite of what the prosecutor did here. I would have thought.
So I think that, if this issue had been raised and there had been a ruling that they were not mutually admissible, then I think, of course, it would have been tried differently. I do want to say, Your Honor, that I think that there's an instruction given to the jury that they consider the evidence of each offense separately.
No, I don't think that's. Do you have the exact wording of that instruction in front of you?
I have.
I thought they said consider each count and separately, render a verdict on each count separately and consider for that count the evidence that is relevant to that count. That's my paraphrase. I don't have it in front of me either. That's a completely different topic. I don't think anyone told the jury, and in your view, it would have been incorrect to tell the jury, don't consider any of the evidence about the third carjacking in figuring out whether the defendant is guilty of conspiracy to steal. I thought your mutual admissibility argument is if the jury had been told that would have been wrong. That's the opposite of what the jury should have been told, because the jury should have been told it all was logically relevant and could be considered together. But instead, the jury was given kind of that standard instruction, which is not very clear, but I think normally is understood to really say, don't, if you're the jury, consider whatever evidence is relevant to the first count, render your verdict on it, then don't say, well, he's guilty of the first count, so, he's guilty of the second. You have to go to the second and consider guilt on it and consider all of the evidence, which might be circumstances that relate to the first count. Do you have the exact wording of the instruction in front of you?
I do. And the exact wording of the instruction is each count charges a separate offense. You should consider each offense and the evidence that applies to it separately, and you should return separate verdicts as to each count. The fact that you may find the defendant guilty or not guilty on any one count of the indictment should not influence your verdict with respect to any other count unless I instruct you to do otherwise.
So you would
What page
agree.
is that on?
I'm sorry?
What page is that on?
That's the November 9th transcript at 112.
So you would agree that, like, if one of the charges is aggravated assault against one of the carjacking victims, the jury wasn't supposed to consider only the evidence of punching and couldn't consider any of the evidence of the fact that there was a carjacking and, other pieces of evidence. The jury doesn't have to, look at each incident or each crime and look only at the nexus of operative facts that relates to it. That instruction doesn't tell the jury to do that, does it?
I mean, it tells the jury to consider each offense and the evidence that applies to it separately.
I'm just asking what that means.
I mean,
let me ask you this. Do you think the jury hearing that instruction should have disregarded in figuring out whether the defendant committed, let's say, the first carjacking, should have disregarded any evidence that related to the fact that there was a conspiratorial agreement earlier on and the robbery, the car thefts that preceded the first carjacking? Should the jury have considered that appropriately in finding guilt, or should it have ignored all that evidence in finding guilt on the first carjacking under that instruction?
I think they should have considered that.
So how does that instruction, if that's true, I don't understand how that instruction helps the jury not amalgamate the evidence in a way that is different than if there had been a separate trial where there was no mutual admissibility.
Well, so I think there's a difference between fairly considering evidence of one crime for another and unfairly doing so. And so, again, if this was litigated and there was a finding of what was mutually admissible and what was not, then there could have been more tailored instructions as to what could have been.
We're talking about harm right here, and we're trying to figure out what guide rails were, put in place for the jury. I'm looking at the instruction that was given on page 154, which is sometime after the instruction you read to us, where the court, right before it dismisses the jury, says, it's entirely up to you to decide what facts to find from the evidence received during this trial. You should consider all of the circumstances and the evidence that you think are relevant in determining what the government has proved beyond a reasonable doubt. I mean, that just seems to say, hey, you figure it out. I'm not going to put any limits on how you mix and match the evidence here. So how do you think that impacts the harm analysis?
I mean, I think the first instruction that I read to the court is more specific about what they should do on each. This is the last instruction
that the jury heard right before they left to deliberate.
I understand that, and that instruction is about. I think
we've got cases that say kind of the last thing that the jury hears is pretty important.
I mean, that's a fair point, Your Honor. I do think that, that instruction is targeted towards, I think my understanding of that instruction is that the jury is the finder of the facts, whereas, the judge tells the jury about the law. But I think that it's sort of beside the point in this case, because the jury's verdict showed that it did consider each incident separately. I think that appellant's counsel talked about.
Again, you lose me when you say consider each incident separately. Your argument is that the jury should have been considering evidence of all of the incidents and figuring out the guilt of any particular one. And that it was all mutually admissible and there should have been no limit. So they weren't required to consider the evidence of each incident separately. I thought your argument was they appropriately considered all of the evidence in finding guilt as to any particular part of the set of charged offenses.
I think that's correct. I mean, I'm not saying that, mutual admissibility doesn't mean that everything for all the crimes is admissible in the trial of the other, right? It's that the crimes themselves are mutually admissible.
No, I mean, actually, it does ordinarily mean that, and we have some cases where we sever, or we reverse trial judges for failing to sever, because although charge A and charge B were mutually admissible to a degree, there were really heinous parts of charge B that wouldn't have had to come in a separate trial of charge A. And what we said the trial judge ought to have done is to kind of sever and redact, where charge A would come in with a little bit of evidence from charge B, but not the really bad stuff. And then charge B would be tried separately. So I don't think it's right that mutual admissibility is kind of a partial concept. But maybe you can help me again with my where I just run up against, in part, my limitations of my understanding of our own law. But if you are arguing separate and distinct as an alternative ground why severance could have been denied here, so you're assuming mutual admissibility doesn't apply, then I don't understand how that could work here. Because if on that theory, the jury would have had to have been told, don't use any incidents, depending on how, like let's say it was going to be severed into 3 trials in theory. The jury would have to have been told, look, you've got a set of charges relating to conspiracy, you've got a carjacking, you've got a second carjacking. They're being tried for convenience together, but we're going to try them separately and distinctly. We're going to tell you evidence about the conspiracy. Then we're going to give you some evidence about the first carjacking. Then we're going to give you evidence about the third carjacking. And, judge, instruct the jury, consider the evidence relating to that first incident, only the evidence that was introduced as relevant to that. Then you're going to have a whole separate, hermetically sealed set of evidence that goes to the first carjacking. Then you're going to have a third. And the prosecutor, the evidence would be introduced separately. The prosecutor wouldn't amalgamate it in closing. And the jury would be told, don't, take each one as its own box and don't allow any mutual admissibility. I mean, I can see that is a possible way in which you could argue that there was insufficient prejudice to require severance in the absence of mutual admissibility. But what I don't understand is where that's not the way the case is tried. That's not the argument is that actually they were all mutually admissible. And that's what the jury was essentially told to do by the prosecutor and permitted to do by the instructions. I don't understand how separate and distinct could be an independent ground for affirming a failure to sever on a record like that. That's where I can't get my head around it. I don't understand it. So I don't know if you have any further light to shed on that, but I can't see this as anything close to that.
Well, I'm not sure that hearing that I will be able to convince you of anything, Your Honor, but I will just note that the jury does, appellant's counsel talks about the prejudice from the stabbing of the zoo carjacking and how that was very, it's a heinous crime. And we know that the jury didn't just hear about that incident and then say, oh, he's guilty of all the other offenses. Because there's a mixed verdict on the incident of the stealing of Robinzine's car. The jury convicts appellant of UUV, but not of first-degree theft and destruction of property for that incident or for that portion of the conspiracy. And then, of course, the jury doesn't convict appellant of the armed offenses when it comes to the Gathers carjacking. So I think that the mixed verdict does show that the prejudice is not there that is required by Rule 14. If there are no further questions, I just again want to point out just now that I'm out of time that the government does believe the evidence in this case was overwhelming, such that even if the cases were tried separately, it still would not have made a difference. And we'd ask that you affirm the judgment of the trial court.
Thank you, Mr. Hahn. Ms. Persico will give you just a couple of minutes.
Okay, thank you. I'd like to just focus on 2 things. I'd like to go back for a second to Roper and Judge McLeese when you asked the prosecutor whether the cases say that you never look outside the indictment. If you go to Roper, you can see, as I argued before, that they considered both the elements of the indictment and the facts. Look at footnote 5 in Roper. This is what Roper relies on, a whole list of cases where they talk about how the facts in those cases, they distinguish the facts in those cases to show that the crimes were similar. So that shows you that Roper definitely considers not just the indictment, but the facts in the case. And I'd also like to go to this whole argument on separate and distinct. All you need to do is look at the Thomas case that we cited in appellant's brief and reply brief. Thomas is your roadmap. In Thomas, which none of this occurred in the current case, in Thomas, there were preliminary instructions to keep all of the crimes separate. In the opening statement by the prosecutor emphasized that the charges were to be considered separately. The prosecutor did not do that here. In this prosecutor's opening, she told the jurors, the defendant wants another car now. He knows where he can get. He wants that thrill that he experienced when he beat Mr. Gathers, and he wants to take the next step. He wants to kill. In Thomas, the entirety of one case was presented before the entirety of the other case. Not so here. They went from Gathers to Zoo, and then who did they go to? Waters, and he testifies about all the crimes, all in one sitting in the testimony. And then you get to the prosecutor's closing and the prosecutor's rebuttal. The government only mentions the closing and says it was only that one line. Not so. In our briefs, we set out exactly what the prosecutor said. In the closing argument, she told them to consider how those two crimes actually reinforce one another. In her rebuttal, she told them right out, don't look at these crimes, at the evidence in isolation. Look at how they strengthen one another. So, and then you go back to Thomas again. In Thomas, the judge actually did instruct again at the end of the trial to keep the charges separate. So if you look at Thomas, there's your roadmap. And this case does not follow that roadmap in any portion. Unless the court has any other questions, I'm going to ask that you reverse the trial court's ruling, find that counsel was ineffective, and remand for a new trial.
Thank you. Thank you, Ms. Persico. Thank you, Mr. Hahn, both of you for your arguments today. The case will be submitted.
Thank you.
And you all are dismissed.
Thank you.
Thank you.
Today. Good morning. The next case we have on our calendar this morning is 19 BG 240 in re Johnny Lewis Johnson III. Mr. Johnson, when you are ready, if you could let us know how much time you would like for rebuttal. And Mr. Johnson, you are you're sort of fading in and out into the background.
We talked about that, and I don't know what's going on. I'll try not to move. It only happens when I move, so I'll try not to move.
Well, that seems distracting for you. If you would prefer to turn off the background, I mean, maybe you're not camera ready to do that, but if that would be easier for you, we'd much prefer to see you than to see the photograph of the courtroom.
Yeah, I'll try not to move.
Okay.
Thank you. 5 minutes for the rebuttal.
All right.
Right.
Whenever you're ready.
Yes. As I stated in the papers, the disciplinary counsel got the information incorrect. It was not, as they stated in their papers, the claimant who alleged that money was taken out of his check was wrong. He had the papers showed that he was wrong. There was no money taken from him. He deposited his check and dispersed the funds himself. So it was not District of Columbia funds, but it was his funds. And he gave them out. And so that was, for that allegation, there was nothing to support the allegations of a disciplinary counsel about Johnny Johnson taking the funds and using them to the detriment of Mr. Glover.
Mr. Johnson, what do you understand what did you understand Bar Counsel to be suggesting with respect to that charge? Because I think I read the Bar Counsel's list of concerns, its complaints, in other words, that you had inappropriately taken a portion of the check that should have gone to your client because you asked for monies in excess of what you were entitled to. I didn't understand them to be arguing that somehow you, after he deposited his share of the money, you took some of his money. Why do you think, is your argument that, and I think it is, that at the point that you divided the money up pursuant to your retainer agreement, that the money was yours, the 30% was yours, all of it, and not his, or that he could agree to give you monies in excess of the statute, and that's what he did, and that's okay because it's his money? I'm a bit confused as to what you're arguing here as to what they failed to prove.
They failed to prove that in their paperwork, they alleged that the Johnny Johnson cashed the check himself, dispersed the money himself, and it was that was inappropriate. And my argument is that Mr. Glover himself cashed the check and dispersed the funds. Based upon the agreement that he had, that Johnny Johnson did not cash any of the money, did not take any of the money. It was Mr. Glover throughout the whole process who actually did the dispersing of the funds. And I'm saying that was incorrect.
Well, leaving aside whether disciplinary counsel's allegation was incorrect in that respect, I think the Board on Professional Responsibility and the hearing committee ended up concluding that, if the circumstances were as you're describing them, that was still impermissible and in violation of statutory requirements about how much money you could receive through whatever means from your client for this representation, and also of a need for court approval. So do you think, do you have an objection? Again, leave aside exactly the way the allegation originally came up, but in terms of what what the Board on Professional Responsibility and the hearing committee found, do you dispute that it was unlawful for you to enter into the agreement to be compensated in that way, and then to obtain that payment without court approval and contrary to statute? Or do you think that actually that was entirely lawful?
In terms of the use of the word lawful, I don't think it was unlawful for me to have entered into an agreement with my client for him to disperse the funds according to the way he wished to do so. They were his funds, not District of Columbia funds, which disciplinary counsel was arguing.
Well, again, leave aside what disciplinary counsel was arguing. What the board ended up saying was there's a statute that whoever, it doesn't matter whose funds they are, the way the way the board was looking at it, there's a statute which says it's just illegal for an attorney who's representing somebody in a workers' comp case to get a fee over 20% and to take that to be paid for that representation without getting court approval. Do you agree that your conduct was contrary to that statute?
No, I do not agree.
And how is it lawful under that statute? I know you challenged the constitutionality of that statute, though your opponent cites a case called Cornelius that addresses that. But just under the statute, why do you think your conduct is lawful under that statute, assuming it's valid?
Well, I'm sorry, I can't cut my phone off here. Well, I don't think it was unlawful because, as I stated in the paperwork, Mr. Glover had come to the law office of Johnny Johnson, said that he couldn't get anyone to represent him. And he agreed that if in fact I would represent him, that he would give me the customary fee. It was not something that I came up with, but it was something that he came up with. And based upon that agreement, and that was the only reason that the office decided to represent Mr. Glover in his workers' compensation matter.
Well, could you turn to the language of the statute and try to, again, help me understand why you think it was lawful under the statute to enter into an agreement to receive such a fee and then to receive payment for those services? I'm focused on DC Code 1-623.27C, which says a person who receives any fees on account of services rendered as a representative of the claimant, unless such consideration or any gratuity is approved as part of an order, shall be guilty of a misdemeanor. So there was no court order at the time you obtained the money. And so it seems like your conduct was covered by that provision, leaving aside the 20% aspect of it for a minute. So what's your argument about why that your conduct was lawful under that statute?
Because as I stated before, it was an agreement between the client and Johnny Johnson that he would offer and the fee, and it was accepted. And that is the reason. It wasn't anything other than that. He had a right to decide whether in fact he wanted to disperse or deal with his money any way he wished to do so. The money became his.
That may be so, but the language that Judge McLeese read to you speaks to your obligation and says that a person may not receive those fees, right? So it prohibits you from accepting them. And I'm wondering how you work around that language.
As I stated, he decided he wanted to disperse the funds any way he wished. But they were his funds, so he could.
Right, but again, I'm talking about your obligations under the statute, and it says a person who receives any fees. You were the recipient, intended recipient under your presentation of the facts.
Right.
Under your presentation of the facts, he came to you, he wanted to sign this agreement giving you 30%, and he tried to give you 30%, but you were prohibited under the statute from receiving them, and yet you took them.
Only because they were his funds, and he decided to take that argument to this logical extent. No person could disperse funds to an attorney any way he wished to do so, because the argument is that he doesn't have the right to do so. And that my argument, that is unconstitutional. He has a right to do.
Yeah, I understand you're challenging the constitutionality of the statute, and that's a separate set of questions. Your opponent cites a case of ours called Cornelius, which your opponent says, disciplining counsel says, has already established that the statute is constitutional. And so what's your response to their reliance on the Cornelius decision?
It's the argument is that they're arguing about that aspect. I'm arguing about the fact that they're suppressing any claimant's right to disperse funds. And so that the funds, wherever they are, go beyond what is required. If in fact the funds are his, the government cannot tell him how he can disperse his funds, no matter where he disperses them.
Well, your opponent argues that we held otherwise in Cornelius. Do you disagree with that? And how do you understand the Cornelius decision if you think that it isn't inconsistent with your argument?
I think it's inconsistent because what we're talking about here is something entirely different. We're talking about a person having a right to disperse funds the way he or she wishes to do so, as opposed to saying the funds that can be traced from the government and given to a particular party. So that's the distinction with the difference.
in this proceeding, you testified that you recognized that the statute had that limitation. So what you're arguing here is that you only recognize that limitation on your fee, on what you could receive in fees, if the money was dispersed by the government.
That's correct.
And now and suggesting that the constitutional validity of the statute is limited to only fees dispersed by the government.
That's correct.
Okay. I just want to understand the argument, though. You don't have any case law. You cite no case law for that proposition or any authority from other jurisdictions or, frankly, any authority from anywhere for that proposition. And the statute and the case itself, Cornelius, doesn't seem to make that or express that limitation, suggesting it's limited to only funds dispersed by the government. Statute certainly doesn't read that way. So what is your authority? What is your best case? What case could you cite? Because I didn't see any in your brief for the proposition that Cornelius is so limited and this right exists that you are indicating is a constitutional right.
I don't have any authority at this point to offer.
And can I ask you how you reconcile your distinction with Cornelius itself? Because in Cornelius, the lawyer who was trying to argue that the statute was unconstitutional was trying to recover on a contingency fee agreement between himself and the client. It didn't involve government money.
Well, the difference is that in this particular instance, the disciplinary counsel is arguing that it was the funds that were dispersed to him from the government that they're trying to trace to him, and he didn't have a right to decide how he wanted to disperse his funds.
I guess I'm trying to figure out why your conception of the statute would make any sense. Because if you look at DC Code 1-623.27B2, it says this is how awards shall be made, right? You get a reasonable attorney fee not to exceed 20% of the actual benefit secured, which fee award shall be paid directly by the mayor or his designee to the attorney 30 days after the date of the compensation order. And it seems to me that what this does is create a statutory scheme that is supposed to protect a vulnerable population of litigants, right? People who might not be well-versed in the law, might not have training, might not be the most, sophisticated consumers, but they need funds because they have been injured on the job. And what the statute does is create an incentive for some portion of the bar to represent these folks with a guarantee that they'll at least get up to 20% of the compensation awarded, but no more than that, and that the money has to go through the mayor or his designee, cannot be paid directly by the client because we're worried about situations arising precisely like the situation that arose in this case.
Well, as I stated, there's a distinction between that and what happened in this particular case here. The claimant.
I guess my question is, why do you think that provision 27B subsection 2 was even written if it allows for what happened here? What was the point? What's the point of that provision in the DC Code?
I didn't look at the legislative history of that portion of it, so I can't respond to that. All I can say is that because Mr. Glover was at a crisis that he couldn't find any representation, and he came to my office and said that he would be willing to enter into the agreement. My office said, yes, we will do it, and for the customary fee. And it did not come out from the funds.
I'm sorry, did you say this was the customary fee?
The customary fee
was 30%?
Yes.
But I thought earlier you said that he came to you and said, I want to pay you 30%. So it's coincidence that he came to you and said, I want to pay you 30%, and actually that was your customary fee?
That is correct. And he agreed to it, and because initially my office
He agreed to it or he proposed it?
both. He proposed it and agreed to it.
Okay,
Initially, my office had declined to represent him until he decided that he said we will pay the fee because I can't get a lawyer to represent me.
And when you say the customary fee, are you suggesting that you do other workers' compensation cases and that this is how you typically handle worker compensation cases?
No, that's not what I'm suggesting. In this particular case, because it was a difficult case, I came up with the fee, and he.
Well, now you're puzzling me a little bit more because I thought you said it was the customary fee, and now you seem to be saying that it was a higher than usual fee because of the unusual complexity of the case.
That's not what I said, but if in fact you want to look at it that way, you can. But as I said,
well, no, you said that you worked out the customary fee. And so I was asking, do you do other workers' compensation cases? And is this your customary fee in workers' compensation cases? And I thought you said, no, this was a particularly complicated case, which does seem to imply that you've done other worker compensation cases of average or less complexity for a lower amount than 30%. But maybe you mean to imply something different. If so, you could, feel free to tell me what you do mean to indicate or imply about that.
I did do other workers' compensation cases, and the fee was what was required, the 25 or 30%, 28% for the fee, and of course that is what I'm saying.
So was there when you say a customary fee, do you mean one of the options that you sometimes used, or do you mean the option you most typically used was 30%, or what do you mean, I guess, more precisely when you say that the 30% here was the customary fee that you charged in workers' compensation cases?
Yeah, because I had another case where the judge ended up not giving me any fee whatsoever. So that's why I said the customary, because I would want to at least get paid.
Well, the question of what your agreement at the front end is and what you ultimately got paid is a little bit different. So in terms of when you entered into an agreement with a client to do a workers' compensation case, was the most typical fee you used 30%, or was that one of the options but not the most typical one?
Well, I say that because my agreement says that that is the fee, but the judge may have another fee that he would order in the particular case.
Well, let me try my question again, just to see if I can get a direct answer to it. So, you've said you did a number of workers' compensation cases.
That's correct.
And my question is, with respect to the agreements that you entered into with your clients at the front end to handle those matters, was the most common, I gather, first, is it true that the percent contingency sometimes varied? It wasn't always the same. Is that true?
Yes, that is true. Because
okay, good. So what was 30% the most typical number that you used? Because you said you've used several, or was it not necessarily the most typical?
It's not necessarily the most typical. As I said, the agreement says that it's up to the administrative judge to decide what fee would be issued.
The agreement in this case says that?
Yes, that's correct.
All right. I have
All right.
further questions at this
Thank
time.
you, Mr. Johnson. We'll hear from Ms. Porter and we'll give you some time to respond and rebuttal.
Thank you. Good morning. May it please the court, Julia Porter on behalf of the Office of Disciplinary Counsel. The respondent, Mr. Johnson, took an illegal, an unreasonable fee from a vulnerable client. The client did not willingly pay this fee. The client was never told that the government would pay his fee if it were successful, nor was the client ever told about the limitations on legal fees for lawyers representing claimants in workers' compensation cases. Indeed, this action. Yeah.
I'm sorry, Ms. Porter. I'm hearing a little bit of feedback. Mr. Johnson, could you mute your mic while you aren't speaking? I think that might help. Thank you. Continue, please, Ms. Porter. Thank you.
The client's own actions demonstrate that, because when the client was informed that there were limitations on the legal fees of lawyers and that the government, the DC government, would pay the legal fees if he prevailed, he complained. He claimed he filed a fee arbitration claim, he filled out a complaint form, and he complained to the administrative law judge. Respondent was deceitful with his client, as the hearing committee and board found, and that deceit and dishonesty continued when he was confronted by the client's successor counsel, when he was asked to show cause by the administrative law judge, when he was questioned by the disciplinary counsel, and the false and dishonesty continued in the hearing, where he gave knowingly false testimony to the hearing committee. This was the exact type of situation that the workers' compensation law governing attorney's fees was meant to cover. Mr. Johnson took 1/3, not 30%, although I guess the difference is relatively minor, but he took 1/3 of his client's recovery as attorney's fees after receiving the check and meeting the client at the bank. There is no dispute that he received the 1/3 amount, because we have the checks from the bank. We also have Mr. Johnson's own disbursement letter or memo that he provided the client saying, I'm taking 1/3 of your compensation benefits as my fee, as your counsel in the workers' compensation.
Does it
Ms.
say
Porter?
anywhere in there, I'm sorry, just one quick
Okay.
factual question. Does it say anywhere in the retainer agreement that it is subject to approval by the ALJ?
I think what the retainer agreement is confusing in that it sets forth, I guess, many options for fees. One being the $500 an hour, another $5,000 a day, another 1/3, and that there is a reference to the workers' compensation, subject to the workers' compensation, but it doesn't say that the workers' compensation legal fees are limited to 20%, although Mr. Johnson admitted that he knew that, but he never disclosed that or never told his client that.
I'm just not seeing where it makes reference to the workers' compensation. Oh, maximum allowed. Okay, I see
Yeah.
it now. And under billing problems.
And Ms.
Sorry.
Porter, is it the board's position that at the point he took the 1/3, he actually violated 1.4B? That at that point, regardless of what he said, which goes to dishonesty perhaps and other things, that at the point where he accepted that fee in excess of 20%, it was a violation of 1.4B because it was an unreasonable fee because it was in violation of the statute.
That's correct. It was in violation of the statute, and the 1/3 contingency fee was clearly a fee for the workers' comp. It was not something that the client was willingly giving over to him because he was a friend or something else. He was giving, the client agreed to that only because respondent had the check and he was at the bank and said, I'm entitled to 1/3 of that for my fee in representing you in the workers' compensation case, without making any disclosure of the limitations on legal fees and the fact that the government, the DC government, would pay those fees if they prevailed.
Okay. Have we had other? I was curious about this charge of a 1.4B for unreasonable fee versus when there's a statute versus sort of misappropriation. Is there a distinction between this being a misappropriation versus an unreasonable fee when you have a statutory limitation?
Well, I mean, misappropriation, as the courts define it, is an unauthorized taking. In a sense, this was an unauthorized taking in that the client didn't have the information that the client was entitled to make an informed decision about whether or not these fees should be paid. The disciplinary counsel didn't charge it as a misappropriation, but rather as an illegal fee, which Rule 1.5 says an illegal fee is per se unreasonable. We also charged a Rule 1.4, and the hearing committee and board found both rules have been violated because Mr. Johnson, the respondent, never explained to the client the limitations on legal fees and the client's entitlement to receive those fees from the, or have the.
Would Mr. Johnson be guilty of a Rule 1.5 violation if he had said to his client, look, I can either take 20% from the government or 30 or 1/3 pursuant to our agreement from you, and the client said, look, take the third?
Yes, he would still be, he would have violated the statute and it would have been an unreasonable fee. The statute is clear that there's a limitation, and even the 20% isn't necessarily guaranteed. There has to be a petition, and the administrative law judge or the board has to review the hours that are spent and determine whether or not this is a reasonable fee given the work that was performed for the client.
Which in this case you contend was would not have resulted in a 20% fee because the work was de minimis.
Right, and the hearing committee's findings, which the board adopted, bear that out. This was
Can I ask you a question relating to that? Shifting over to, in the event we accepted the recommendation of disbarment, you also discuss restitution, and I wanted to make sure, first of all, whether you think we have the authority and are asking us to issue an outright order of restitution, or whether instead, as the board recommended, you are asking us to make any order of restitution a condition of reinstatement.
I think that the court rules, Rule 11, Section 3 says that you can order restitution. I don't think that in previous cases where the court has done so, it's considered like a judgment where the client can then take that and try to collect on it. It usually is there, and it prevents the lawyer from, I guess, seeking reinstatement if they haven't paid it. In this case, and I think we've set this out in our brief, the client security fund has actually paid the client the $19,000 plus, so that we would request that the order of restitution actually be made to the fund, because the fund is the one that's out of pocket. They have made the client whole. Or
I want to make sure I understand your answer. Are you saying that is your request of us that we make it a condition of reinstatement?
That's how I understand, or that's how disciplinary counsel understands that Rule 11, Section 3.
Thank you.
Works.
Good. And the other question I have is, can you walk me through whether we should order full reinstatement, full restitution to the, I guess, the client security fund if there were an effort to get reinstated? Because it seems as though, although there was a dispute for sure about the amount of the work, I gather it was undisputed that Mr. Johnson did at least some things. So is the idea that because the fee is illegal, he should forfeit all of it? Or is the idea that actually it was so de minimis that the full amount was warranted? Or do you think that if we ever got to this point, somebody would need to try to sort out whether, what the actual reasonable value was of the work that Mr. Johnson did?
Disciplinary counsel believes that the court should make order a full restitution, or that Mr. Johnson should be made to provide full restitution with interest because his fee was illegal. The client was entitled to have the government pay Mr. Johnson's fee, provided Mr. Johnson filed a petition in a timely way that accurately set forth his time, and his billing rate would be adjusted depending upon his experience in representing claimants in workers' compensation. So the client shouldn't be out any fees because there is a statutory scheme in place so that Mr. Johnson, if he had spent this time, he could bill the government. He failed to do that. The client security fund And the client shouldn't be penalized because Mr. Johnson, number one, took an illegal fee, and number two, didn't follow the proper procedure in obtaining a reasonable fee pursuant to the statutory requirements.
But Ms. Porter, I guess maybe I understood my colleague's question a bit differently. I understand that his client has been fully compensated through the Client Security Trust Fund. There is an indication that Mr. Johnson did some legal work. So at this point, Mr. Johnson, if he had applied for compensation through the appropriate means, would have been ostensibly paid some monies for his service, for his representation. And I'm trying to understand, what is it that you're asking him basically just because he took some of that money, all of it should be paid back to the Client Security Trust Fund, as opposed to and that's done. That money, the Client Security Trust Fund has paid the client is whole. So you're asking us to hold Mr. Johnson responsible for making the Client Security Trust Fund whole for that payment, but it doesn't take into consideration any fees that he would have earned.
Well, it's disciplinary counsel's position that he shouldn't benefit from his illegal, unethical conduct. Yes, he should not receive any benefit from taking an illegal fee, including retaining any portion of it. As I said, there was a mechanism for him, Mr. Johnson, to collect the fee that he was entitled to for representing a prevailing party. He failed to do that. Indeed, that's part of the misconduct. What he did submit to the District of Columbia was a totally inflated bill that included a number of false entries, which the administrative judge denied in whole because it was untimely, as well as having all these fraudulent entries. So yes, I think that the disciplinary counsel's position is Mr. Johnson is not entitled to any fee under these circumstances, or at least to retain any portion of the illegal fee that he deceptively took from his client and then covered up with years of false statements to, his successor counsel, the administrative judge, disciplinary counsel on the hearing committee, and the disciplinary system.
Although, as it works out, if given that your request is, assuming that we were to accept the recommendation of disbarment, that any restitution to the Client Security Fund would be only if Mr. Johnson were seeking a reinstatement. There's no certainty that the Client Security Fund would be made whole under that scenario. And I take it, I looked a little, and it does seem as though we traditionally enter restitution orders in that way in disbarment cases. I didn't look far enough to try to figure out whether that has to be so, or if so, where we've explained why we do that. Do you have any knowledge about kind of what the background is for that seemingly consistent practice?
No, I don't have any other than kind of the experience with the Client Security Fund. I know that the Client Security Fund will often reimburse a client, particularly when there's a recommendation, in this case, hopefully an order of restitution by the hearing committee board. I would note too that the Client Security Fund, when they make restitution to a client, steps in the shoes of the client, and they have the ability to go after a lawyer for the money that they paid out. I don't know how frequently that occurs, but that is something that the fund can do. And I know that in cases where a lawyer who's been disbarred with the restitution requirement, or sometimes even without a restitution requirement, and the Client Security Fund has paid the clients, we, as part of the reinstatement investigation, will insist or require that the lawyer, reimburse the fund for any payments they've made. But as far as kind of a freestanding restitution order which a client can take to the bank, I'm not aware of that ever occurring.
Yeah, I thought this arose because we had initially, or at some point in the past, we were conditioning this not reinstatement, but we were from disbarment, but perhaps from suspensions we were ordering restitution without putting people on probation. And the question was, how did we enforce that? And I think the conversation then turned to what happens if they're disbarred and there is no probation. What is the appropriate way of ordering restitution? But I'm not sure we ever got into a discussion of what the authority was that allowed us to do that. Although it was functionally, we I guess, considered it as part of our regulatory scheme in terms of, not regulatory scheme, but regulatory authority to govern the bar and to govern admissions. The last thing I'd ask is, you are, of course, you have a dishonesty claim, which it sounds as though you are willing to or believe is sufficient to support the disbarment, even without the unreasonable fee. Do you know of any cases where the unreasonable fee was grounds standing alone for disbarment?
I can't think of any other than in the misappropriation context, but we haven't charged misappropriation. But I think that we cited 2 cases that the court has disbarred the lawyers, Cleaver Bascom and McClure. In both of those cases, the lawyer charged or tried to obtain an illegal fee or unreasonable fee, but didn't actually get the money. They were both disbarred. There was also flagrant dishonesty in both of those cases. And this, in some ways, Mr. Johnson's case is worse in that not only did he charge, but he collected an illegal fee from a vulnerable client, as the hearing committee and board found. And that reinforces the need for disbarment in this case, as well as an order of restitution to the firm.
Thank you, Ms. Porter.
Thank you.
Thank you, Ms. Porter. Mr. Johnson, we'll hear from you in rebuttal now.
Mr. Johnson, you're muted.
You're muted.
Okay, sorry about that. First, I want to say that the allegation that a no claim for attorney's fees was submitted is incorrect. It was submitted, and the funds were supposed to go to Mr. Glover. The Bar Council and his counsel decided as a strategy that they would not allow him to accept it. And that was the reason that that was the claim for attorney's fees was not accepted by the administrative judge. The administrative judge decided, taking I guess the short road, said it was untimely. It was in fact timely filed. Anyway, that's one aspect of it. The other is that the agreement itself speaks the fact that the administrative judge makes the decision about how much the fee. I mean, all those the $5,000 a day is the language in some of the standard agreements that the law office has. But in workers' compensation agreements, it specifically states that the administrative judge makes the decision as to what amount of funds would be paid out. And I submit that there was no attempt to deceive Mr. Glover whatsoever, and that, as I said, the claim was filed, and the money was not going to come back to Johnny Johnson. It was going to go to Mr. Glover. And if in fact the strategy used by disciplinary counsel and Mr. Glover's counsel that he obtained had decided not to accept, administrative judge would have certainly considered very closely and probably would have granted a lot of it. And I disagree that the work that was done was de minimis. It was a lot of work done in that workers' compensation case. All the workers' compensation cases are very complex. And while some of the discovery documents and other discovery items, as well as some of the the briefs that were written can be used across cases because the various issues. There was a lot of work done in Mr. Glover's case. As I said, the case was complicated, although disciplinary counsel makes the argument that it was not complicated. I totally disagree. He didn't get reinstated, although he is no longer, he lost his privileges for some other reason right now. He certainly was able to benefit from the work that was done. And I submit that all the other allegations should not be sufficient to disbar Johnny Johnson at all. He's already suspended. I think he should be reinstated. As far as paying the disciplinary counsel the fee, he would certainly take that into consideration, but there was no deceit whatsoever. And that Mr. Glover was told about the administrative judge making a decision, and he understood that. As I said it before, he had indicated that he could not get a lawyer to represent him. And unfortunately, my office accepted it. He should not have under the circumstances, but he did. And I had the agreement to get paid, but the agreement had a proviso saying that the administrative judge made the final decision. Okay.
Thank you, Mr. Johnson. Thank you, Ms. Porter. And the case will be submitted and the attorneys are dismissed. Thank you very much for your arguments
Thank you.
today.
Have a good day.
Thank you both.
Case will be submitted and the attorneys are. Good morning, council. This is our third and last case of the morning. It is case number 19 CV 830, Jacobson Holman PLLC versus Marcia Gentner. Counsel for appellant, if you could introduce yourself and let us know how much time you would like to reserve for rebuttal.
Good morning, Your Honor. My name is John Brennan, and I represent Jacobson Holman, and I'd like to save a couple of minutes for rebuttal.
Very good. Whenever you're ready, you may begin.
Thank you. Several years ago, this firm, Jacobson Holman, suffered a catastrophic departure of partners. And after that catastrophic departure, which threatened the survival of the firm, all the remaining partners, including Ms. Gentner, agreed to an amendment to the documents that govern the then Professional Liability Corporation. And that in that, each of them promised without reservation that if they should leave, then they would forfeit half of their ABA. The ABA is a measure of capital, if you will, accrual basis
Account.
Thank you. Accrual basis account, which is measured in part by cash and measured in part by receivables. Conflict arose among the partners of the firm in 2012. It came to a head in 2013 when 6 of 8 partners departed, and 2 lawsuits were filed, one by Mr. Moskowitz, heard in the Eastern District of Virginia by Judge O'Grady II.
Counsel, we're familiar with the procedural history, so I think we'd like to just jump into the nitty gritty of the arguments. And as I understand it, there's sort of 3 parts to your argument, and I'd like to know where you'd like to focus first.
I'd like to thank you, Your Honor. I'd like to start with the adjustment to the financial statement that was produced prior to the partner departures for the financial year 2012.
Okay, so we're looking at paragraph 3 of the 1997 agreement.
I contend we're looking at paragraph 3 and paragraph 24A of the partnership agreement in part, but yes.
Sure. And so if we're looking at, where this is a contract, and so our court has said we look at plain language of contractual agreements, And it seems to me that paragraph 3, not really meaningfully modified by paragraph 24. I mean, paragraph 24 sort of gives more flavor to paragraph 3, but I don't understand it to modify it. That the plain language, I'll read out loud, says the adjusted accrual basis account shall be that amount set forth in the last annual financial statement for the company prepared by the company's accountant, ellipsis, prior to the date of the withdrawing equity member's notice of withdrawal. So that's the language that I see, and that indicates to me that in this instance, the April 2013 financial report for the year 2012 was the last annual financial statement for the company prepared before Ms. Gentner withdrew, and that should be the operative document. And what I understand you to say is, sure, that's what the plain language says, but that would be absurd. Am I capturing your argument correctly?
Not that the language is absurd, but that the result is absurd.
The result would be absurd because, and what I understand you to say is that's because it doesn't allow for corrections to mistakes to annual financial reports.
That's right, Your Honor.
Okay.
For example, if the financial statement in question came out and the adjusted basis accounts, accrual basis accounts were dropped by 50%, I'm sure the plaintiff and all the other departing attorneys would have said, oh my gosh, that's wrong, we have to correct it. Here, the same thing is true.
You bring up a point, which is one of the points why I found your argument less persuasive, which is, it seems to me that the plain language of agreement is a bright line rule, right? That could cut either way, right? There could be mistakes in the annual financial report that could benefit the firm because it could reflect that the firm's assets are incorrectly low. And so the withdrawing partner would not get what he or she thought was her fair share. Or, as in this case, it could reflect that the firm's assets were incorrectly high, in which case the firm would argue, wait a second, the withdrawing partner is getting too big a slice of the pie. But it's a bright line rule that seems to me that both parties could say, okay, we're going to agree to this. And here's another reason that I'd like you to respond to. It seems to me, because the agreements also require, and I think this is in the 89 agreement, 30 days notice of withdrawal, there is time. Well, first of all, it seems like there's time for the firm to review the annual financial statement before it actually gets issued, because I think they probably don't just come out of thin air. But there is time after any financial statement is issued in that 30-day window for someone to look very carefully at those financials and say, there's a problem here. There's a mistake one way or another that is not it is not accurately capturing the financial health of the firm, which seems to cut against your argument that the plain language should not be read as it plainly reads.
I think, at least in this case, the court should consider the maelstrom of difficulties that was accompanied by a mass departure notice. Wait
a second. I mean, I thought that was an event, but we're just talking about which financial snapshot we should be looking at.
I agree.
And again, we're talking about contracts and we're talking about plain language and whether or not we should be bound by the plain language. And I'm just trying to tease out your argument that we can't follow the plain language because it leads to an absurd result. And I'm trying to press you on that. And so I'd like to get an answer to my question.
I thought Your Honor's first point was that surely there was enough time between the issuance of the financial statement and the departure date for this to be carefully examined and considered and and correct it. I would say to you, though, that if the plain language rule holds, the mistake could have been found the very next day after it was issued. And according to the appellee, tough stuff. You still lose because that was the one that was issued. And I think that's the
Why?
problem.
Why
not
couldn't
whether
it
there
be?
was time.
My point is that it could be amended, right? The annual financial report in this instance came out in April, right?
That's right.
After being reviewed by Mr. Jacobson.
So presumably reviewed by
I
both
think he
parties.
says it in his affidavit that he
Yes.
looked at it. So it's an uncontested fact that he looked at the annual financial report before it was issued.
Yes, right.
And so it comes out in April after he's reviewed it. And then there's a point in time in June, I can't remember exactly the date, when Ms. Gettner says, I'm leaving.
I think it was very early June because she
June
also
17th.
she
And it
requested.
seems to me on June 18th, the firm could have said, oh, she's leaving. I mean, put aside the fact that your clients had already said, hey, we're going to reconstitute the firm and you have to tell us whether you're staying or leaving. So presumably they would have known ahead of time that people might leave and would have had the incentive to review the annual financials. But certainly as of June 18th, they know that Ms. Gettner is leaving. And they have an opportunity at that point to think, okay, she's leaving. She's not going to want to leave empty-handed. Let's take a look at those annual financial reports and see if they reflect the health of the firm accurately, because if we want to get this fixed, now is the time. Because
Your
if we
Honor.
get an annual financial report amended before she leaves, and she can't, she has to give us 30 days notice, then we can get this all settled to our satisfaction.
I think I'm inferring from how the court is offering it, is that if the correction had been done prior to the departure date, it would be okay. But
Well, that's what the
according
plain
to the-
language says, right? It says it's the last annual financial statement for the company prepared by the company's accountant prior to the date of the withdrawing equity member's notice of withdrawal. Oh, it's prior to the notice, you're saying.
Right. So
Okay.
I agree that I don't agree that a complicated financial statement in the midst of a maelstrom of departing partners and the possible death of the firm is going to have adequate time to sit back and check to see if something was missed.
Can I ask you a more abstract contract law question
Yes.
about kind of absurdity? It's a very abstract question of contract law. This is a funny kind of a contract in that, party A agrees to pay party B an amount that's going to be determined by party C, the accountants of the firm, subject to various other things. Well, anytime you do that, there is a risk that a contract that takes that form, party C might make a mistake in calculating whatever it's supposed to be calculating. And that could happen. People could have, agreed to pay, a price reached by an appraiser. So this could happen in other forms of contract. And are you saying that it's just absurd for any contract that says that without limitation to be interpreted as just saying, well, I guess the parties assumed, the risk that the party C might make a mistake in its calculation. And maybe other doctrines, if the mistake is bad enough, there may be other contract, other principles of law that would allow you to avoid the contract in various ways. But just in terms of interpreting the contractual provision, are you saying it's absurd for party A to agree with party B? We're going to engage in a transaction and the amount of the transaction is going to be determined or calculated by person C, and we're going to stick with that number and not have some way of within the contract itself fixing the mistake. The parties can't just kind of assume the risk of mistake because they want to have a fixed number determined at a particular time.
I think the answer is yes, especially where party C issues an opinion, which the accounting firm did, that said this was materially wrong.
And do you have any law? Do you have any law on that says it's just absurd for two parties to say, look, it's always possible that our accountants will make mistakes or an appraiser would make a mistake. That's possible for sure. But we want finality. We want to know, as of a date, we want to know a number people have to pay, what A has to pay B and what B will get from A. And we're going to fix, a number, and the parties are just going to assume the risk that, maybe party C will make a mistake. Have you any law that says that that's just an absurd way of structuring a transaction?
I have no cases that say that idea, relying on party C, is naturally absurd.
Okay, and do you, well, I'm shifting over to events, so I don't want to,
Yes,
I guess I don't really want to shift
Well,
over to event so
before we
quickly,
get
but-
to events, if I could just jump in. So, one, it seems like you have no law to give us. And I guess my question has to go to this issue of gap filling, because it seems like on the one hand, we have Ms. Gentner's argument that says, look, here's a bright line, right? We're going to delegate to party C. Party C is going to decide this. Party C could get it wrong. That could cut either way. It could benefit me. It could benefit you. But we're delegating to party C to have this financial report done by a time certain before I issue my notice, before I give you my notice of withdrawal, right? On your side, we have kind of this it opens this can of worms of, well, how long after the initial financial report can a correction be made, right? How many times can a financial report be corrected? For what reason, right? And so you say, well, we have the accountants, a year after the fact saying, oh, whoops, we messed this up twice. And I'm wondering, is there any limit to that, right? 10 years from now, could the accountants come back and say, well, gee, we know we've already corrected it a couple of times, and she's already at a negative $20,000 balance, but now actually we figured out that she owes the firm $500,000. Would that be okay? And why not?
Because it would be
under
fraudulent.
your conception of the agreement, which is, well, it has to be whatever financial report pertains to the year 2012, but it doesn't matter when that report was generated.
In terms of when it's generated, Your Honor is observing that it takes time to do that. That's simply a fact of life for a complicated law firm accounting. And
I understand it's a fact of life. My question is there anything in your in the agreements that puts any limitation on this, right? Because it seems like we have two choices. We can either look to the plain language that is bounded, or we can walk through this door where there are no limitations, and then it's on us to gap fill, which is something that we don't particularly like to do. We don't like to write contracts for parties. And so I'm trying to ask you, tell me that I'm wrong. Are the gaps not so wide? Are there some limitations that we can infer from the agreements that would limit the number of times a financial statement could be corrected, the time frame, beyond which it could be corrected? Because those seem to be pretty big questions, right? It's already been corrected twice, and a year after she's left, you're telling her now, actually, you owe us $20,000.
I don't think I can prescribe a rule that says there is a time frame. Obviously, the rule would depend upon when Ms. Gentner or someone in her position made the demand, and it was determined that there was an error. I don't think that either of the reports were done for the purpose of reducing them. No one went out and said, oh, we're going to find a way to cut this back. It is certainly uncontested in this case.
Well, I think there have been no facts as to that because there's been no trial, right? There was summary judgment. I was just asking if there was anything in the agreements that would fill some of these gaps for us so that we weren't kind of walking into completely uncharted territory.
I don't think so. The agreement.
And can I ask you about, you're referring to the two adjustments, I'll leave aside the adjustment relating to taking clients away from the firm.
Yes,
but
sir.
on the other two, you're referring to them as mistakes. And I want to make sure I understand why you're using that term. I know that with respect, let me just finish my question. So with respect to one of them, I understand that there is an assertion that the accountants say that there was an accounting error under generally accepted accounting principles, and there was a failure to account for bonuses that were kind of already required to be paid. So I get that as an accounting mistake, an alleged accounting mistake. With respect to the other, could you be very precise in saying, is there evidence or an allegation or a proffer of some kind that the adjustment relating to doubtful accounts reflects an accounting error, that the accountants came in and said that was done incorrectly as a matter of accounting, it's not right, and we're fixing an error? Because I had thought that it was really more in the nature of there was a dispute about how to account for those accounts, no pun intended, and it was resolved one way, then a bunch of partners left, and it was possible for the people who were kind of in the minority to dictate a different way of dealing with those accounts. But I never saw a clear indication that anybody was claiming that was actually bad accounting. It was an accounting error. It was not permissible as a matter of accounting law.
No, you're absolutely right, Your Honor.
But that's not an error.
The second
adjustment is not an error.
The
It's
second
just a
adjustment,
difference of accounting opinion.
the second adjustment was not an error. We recited in the motion papers that there had been a history of the partnership and management of which Ms. Gantner was a part being unwilling to write off, in no small part because the ABA was greatly affected by the accruals of accounts receivable, regardless of the fact that they didn't really represent.
No, I think I understand that. And let me just, so I think that says something about the scope of your position too. Because if I understand your position, it is that even after the withdrawal notice, it is permissible as a matter of this contract for the remaining partners of the firm as an entity, I guess, to go back to the or not even necessarily to get a new financial statement from the accountant, but just say, let's say we'll get a new statement from an accountant, and we'll say, look, you decided a bunch of accounting issues one way. We want you in every area where you decided it one way, but it was, it would have been permissible accounting. It wouldn't have been an error for you to resolve it in a way more favorable to the firm. And we want you to change your earlier account so as to make every assumption, within the bounds of what is legal for accounting. We want you to get a new statement that is way better for the firm. You're saying that's fine as a matter of interpretation, as I understand your view, because it doesn't have to be an error. It can be just any new statement that is issued by the accountant. So as long as the accountant is willing to revise it in a way more favorable to the firm, and that isn't itself bad accounting, you would say fine to change the accrual basis account on the basis of the newly secured, more favorable account financial statement. Is that right?
The second decision or the second result was based on a write-off of accounts receivable. It wasn't.
I'm asking you a general. I'm not asking you about that. I'm asking you about the general scope of your view. And just to make, is your view that if there is an original accounting statement and then there is a notice of withdrawal, and then the firm goes back to the accountants and says, we're not asking you to correct errors. We're asking you to treat differently a bunch of accounting issues in a way that's more favorable to the firm in calculating the ABA for this departing partner. And the accountant says, sure, I can do that, and I'll reduce it by a bunch of things. This is all legal accounting. It isn't the way I was originally doing it, but I can do it that way. That's a permissible, different accounting approach. You're saying that that's all fine, and you could use the new accounting statement as the basis for determining the ABA. Is that right or not right?
That's not what I'm saying. What I'm
why
saying
are you not
is
saying
that
that? To be clear, why are you not saying that? Since you're saying you're going to take advantage of one of the two adjustments that is not a mistake.
Because the court is framing it as though we're telling the accountant, move this, change that, do the other. The reason the second adjustment came up was the firm made, as I think it had a right to do under the last sentence of paragraph 24A, the firm said, okay, you're all departing. Adjustments in account receivables are one of the things that must be done. Admittedly, it was done significantly later, but it was done before.
But it was done at the outset. And that's why I find paragraph 24 not to be terribly helpful. Because it seems to me that in generating an annual financial report, you're always, I'm not an accountant, but it seems to me that it would be a generally accepted way of doing an annual financial report that you account for doubtful accounts. And in fact, the April 2013 report, the initial financial report for 2012, did account for doubtful accounts. It just accounted for those doubtful accounts in an amount that was far lower than what was the amount was later just assessed to be, right? Because, as Judge McLeese alluded to, there was disagreement within the firm as to how to deal with these doubtful accounts. And so they lowballed it with the firm's endorsement. And it was only after Ms. Gentner left and possibly, other people who were in favor of lowballing it, that then the doubtful account number was increased to Ms. Gentner and other departing partners' detriment, right? And so as Judge McLeese was saying, there seems to be a range of permissible accounting decisions that could be made. But doubtful accounts were always in the 2012 financial statement, the April one, the September one from 2013, and then the one from 2014. It's just that the number kept going up.
There was no adjustment to accounts receivable to the accounts receivable write-off for the statement that was July 31st, 2013, which the firm had to prepare in order to address events that occurred prior to the date of departure. I'm not suggesting that this was an accountant's decision. The firm had a right in determining what its own liability was to the departing partners to look at accounts receivable. I agree that some were written off. That doesn't mean that there were valuable accounts receivable that should be included essentially to inflate the ABA of the departing partners. There's no question in the record that I think $500,000 of accounts receivable written off in the second financial statement were of any value. They weren't. And everyone knew it. And the fact that there was an impasse, that the managing committee refused to adjust them, and that the firm thereafter, the two remaining partners, decided to write them off, was not an indication that there's some sort of manipulation.
Now you're losing me a little bit because you seem to say that there's no dispute that those accounts receivable were of no value. If that's true, why wasn't the failure to write them off in the earlier statement an accounting error?
Because
it's got to be an accounting error to fail to write off. Or is that not right? It's in the discretion. I don't know accounting. So
accountants don't write matters off. The attorneys, the law firm, looks at their receivables as, you know what, these are not worth a darn thing. And we've got to face the facts that they're not worth a darn thing and stop pretending that our ABAs and the value of the firm is X, Y, and Z. They're not worth anything. And there's
maybe it's a semantic, it's a terminological difference, but I assume that accountants, if what you're saying is it's not the professional judgment of the accountant that determines whether an account is written off as doubtful, that's the accountant is given directions on that by the firm. Is that what you're telling me? Because I assume the accountant has to adjust the spreadsheet to write off accounts recitable.
Yes, you're right.
So they do write them off. It's just that you're saying that the accountant plays no role in determining whether it's appropriate to write off accounts receivable. That's entirely up to the professional organization who the accountant is providing accounting information for.
Exactly so.
Mr. Brennan, but doesn't, and I'm going back to the point made by my colleague, Judge Easterly, this is a partnership agreement. Why would a departing partner agree to a process by which they could be completely undermined by prior or by subsequent decisions in terms of what they're entitled to under the agreement when they leave? Because I mean, it just makes absolutely no sense from the perspective of a partner. I'm talking about any of the partners to say, I will leave, and over the course of time, you determine, even though it's contrary to the plain language of the agreement, I will allow you to determine whether, in fact, the value of the firm should be A, which it was when I left, according to your own accounting, or B, which is what you now said it is after you have reviewed and made separate decisions. I mean, that to me sounds ludicrous from the perspective of you or anybody else entering into a partnership agreement where a key element, a key provision of it is, what is my value and what am I entitled to receive? And the fact that you have a bright line, plain language that says, hey, we're willing to rely on our accounting on a date certain as to the value, which can't be manipulated, and you're entitled to it. I just, because anything short of that, first, doesn't make sense to me as somebody who's a former partner of the firm, but also doesn't make sense from the perspective, because you control those financial documents. The firm controls them. They can make those decisions as they go along. But to suggest that my ability to recover my value of that firm is dependent on later decisions just makes no sense. It makes so much sense that there's a bright line here. And the gap filling that Judge Easterly suggested can happen seems to just be counterintuitive for anyone who is invested their money and has been part of this process for the 30 years that Ms. Skinner was, but certainly any length of time. I just don't understand how. I understand from the firm's perspective, looking backwards, it's a good thing for the firm. But this is a partnership agreement where people are coming in saying, I'm entitled to how much will I get if I leave this firm? And I think for a good reason, it's not contingent upon any later developed financial records that may or may not be consistent with prior years' financial records, or the financial records immediately established immediately prior to my leaving. I just don't understand how we can read into this contract any ambiguity that lets us even get to the point where we can interpret it that way.
If the contract said that the financial statement for the year end could not be changed, I would have to agree with you. It doesn't. The agreement doesn't say that. The agreement says that the financial statement that's produced prior to your departure shall be adjusted for events occurring prior to your departure. And if it's, for example, Your Honor, a firm could suffer.
Oh, I don't doubt that.
No, it doesn't say shall be adjusted. I don't think so. I think if you're looking at paragraph 24A, the language that survives, right? Because I understand that you have agreed that certain language from 24A doesn't survive, right? The penultimate sentence has been superseded. But the last sentence, is that correct?
We contend that the adjustment for doubtful accounts receivable survives, and that's what the firm did. If Your Honor looks at paragraph.
But that happens within the issuance, within the generation of the initial financial report.
No, Your Honor.
Right? There is a line item for doubtful accounts in the 2012 report that is generated in April 2013.
There is.
So, and it says, and that complies with 24A, the final sentence of which says, in establishing such adjusted accrual basis account, the accountant shall include a reduction for doubtful accounts based on prior experience of the partnership. And the accountant did that. It does not, 24A does not say you can go back and fix an annual financial report later in time.
24A sets up a different structure. It says when you withdraw, the accountant shall prepare financial statements showing the value of the ABA. Then it should include, must include in that final financial statement, a write-off. The fact of write-offs in the prior year, which apparently they were able to agree on, does not mean that when the final financial statement reflective of July 13, 2013.
Well, the July 13th statement, sorry to interrupt, goes because we're talking about the last annual financial statement, right? And that's 2012. Now we're talking about that was prepared before the withdrawal. Now you're talking, I think, about events, which Judge McLeese wanted to ask about. And here, the events, first of all, I find the language regarding events to be a little bit confusing because the events don't modify the accrual basis account. The language regarding events says with adjustments to the withdrawal date
No, you're right.
solely for events occurring in the period between the closing date of such last financial statement and the withdrawal date.
It's not an adjustment to the withdrawal date, Your Honor. It is.
Well, that's what the
considering-
language says. So I would like you to
I just-
explain to me.
Let me, are you on paragraph 23, Your Honor, or paragraph 3?
I'm still looking at paragraph 3.
Okay. Paragraph 3 describes a process where a financial state, once a partner decides to leave, if there is an existing financial statement, which there was here,
Right.
that financial statement gets adjusted for events up to the date of departure.
Right.
But
And I
it's
but I
not
just read
fixed.
you the plain language of it, and it says with adjustments to the withdrawal date.
Meaning adjustments in the firm operation up to that date.
Okay.
Not an adjustment of the partner's departure date, an adjustment to the firm's financial situation as of the changes on the effective date of departure.
Okay. So it's a true up provision, right? I mean, you have the annual financial statement that gives you the snapshot at the end of the last year. And now, depending on when the partner leaves, they could leave in the spring, they could leave in the summer, they could leave in the fall. Many things could happen in that interim. The firm could get some big judgments. This firm could suffer some big losses. This brings you up to date. This adjustment for events provision, right?
Yes, Your Honor. All of those things would be taken into account.
All right. So, but my understanding is that you've said, well, the doubtful accounts are an adjustable event. But for the reasons I think that we've already discussed, I struggle with that because these doubtful accounts were known to everyone. What are the other events that you would like us to look to adjust the accrual basis account?
It's our contention, Your Honor, that the mass departure of the partners was an enormous event. And that event.
Nobody left before Ms. Gentner.
I'm sorry?
Nobody left before Ms. Gentner. She was the first to go.
Everyone resigned before Ms. Gentner's departure. And
I
that's
think
one
they
of the-
gave notice of withdrawal. I think one partner gave notice of withdrawal before she left.
all of them gave,
But that person did not leave.
all of them gave notice prior to her departure date. All of them did. And that's what the trial court looked at it and said, okay, I know you've been told all your partners are resigning, but I'm only going to consider their actual leaving, going out the
Is
door.
that
as an
is that in
event.
the record
Which is in the record?
that all of them said that they were leaving the firm?
Yes, Your Honor.
Because
can't
I
put my
thought
hands
some
on it.
people said that they were not leaving the firm. They were saying, I might step down as an equity partner.
One-
None of that was effective, right, before she left.
Well, that's exactly right, Your Honor. If the court looks at event as only walking out the door, yes, that's right.
Well, I
I
guess
contend
my
that
my
the-
question is, how does that affect the firm's financial health? If I'm a
Desperately.
partner at a law firm and I say, I'm leaving in 60 days, I can see on day 61, when I'm gone, my departure affects the firm's financial health. How does my announcement that I'm leaving in 60 days affect the firm's financial health the day after I make that announcement?
We don't contend that the announcement affects the financial health. We contend that it is an event which permits the firm to make adjustments. And
Well,
that's
but
what
doesn't the
paragraph-
event have to have some connection to the firm's financial health?
Well, here's the connection.
That's a yes or no question.
Yes, and the connection is the ABA of each of the departing partners is going to be a tremendous drain on the firm.
So,
And
but
that's
that gets
the
me
event.
back to my question. If the answer is yes, it has to have a connection. how does my announcing that I am leaving in 60 days affect the firm's financial health the day after I make that announcement?
There is no dollar dropped from the financial statement because someone makes that announcement. We still contend it is an event that affects the firm, and that event permits the firm to examine its own financial health, including.
So let me give you a hypothetical. So imagine there's a firm that has 11 partners and 10 of them decide they're going to leave, and all 10 of them have an ABA as of the last financial statement of $1 million. So the firm would owe each of them $1 million if they left. And assume the firm has, $20 million in the bank. The firm ends up saying, okay, as to, whoever it was who, one of the, as to all of them, I guess, says in between the notice of withdrawal and in between the time of the last financial statement and your withdrawal date, we've learned that a bunch of other people are going to withdraw. And that doesn't really affect our books in any way, but, we really don't want to pay out $10 million to all of you. We could, and it's not an accounting piece of information, but if the issue is, well, is this going to be a firm that's going to go forward very well in the future? The answer is maybe not. You're saying that the firm, that would be an event that would allow the firm to, I don't know, do what, say, well, I guess we'd like to pay a lot less than everybody's ABA the way accounting folks would decide it, because it's just going to be bad for the firm going forward that a lot of people are leaving. Is that?
I don't think we're contending that. We're contending that if the
well, that's an event, right? Wouldn't that be an event? If your test is anything can be an event, as long as it affects the firm's financial health going forward, even if it doesn't, like an accountant wouldn't use it in determining the balance sheet of the partnership. Then it does seem to me that you're opening the door to that. And unless you have some different definition of event and financial health that will narrow it, it seems like you're adopting a very expansive view. So
the word event is a very expansive event, which is where I think.
Understood. So, can you tell me, do you have a definition of event or firm financial health that would exclude the hypothetical I just gave you? Or do you think actually no?
Because firm financial health is not a phrase used in the document.
No, it was used in your description. It was used in, I think, your some of your, maybe it was not generated by you, but it's been sort of seemingly endorsed by you as part of how we would figure out an event that was relevant. I mean, I assume you would say an event that has not, if the team X wins the Super Bowl, that's an event, but it has nothing to do with any of this. So we got to find some way of your definition of event is anything that happens. Fair enough. Fair enough. No, fair enough. But you can't really mean that this reserves to the partnership the ability to, without any control by any accounting principles, if there's anything that happens, to just freewheelingly adjust people's ABA however it wishes.
Well, let's take what was actually done rather than what might be done in the universe of words. What was actually done was a mistaken financial statement was issued during that period, and that was fixed.
That's half of what was done. That's half of what was done.
And then the paragraph 3 does say you will make adjustments for any events. And if the event
no, it doesn't say you will. It just says with adjustments solely,
adjustments,
which again may require, may permit, a little unclear, but it definitely doesn't use words like will or shall.
You're right. It doesn't use the word shall, but it certainly is within the control of the remaining partners to make
again, if we're trying to figure out whether the trial court was correct to rule against your client as a matter of law, or whether instead there was a jury issue here about events, you agree that you couldn't just instruct a jury. The partnership is free to make any adjustments it would like to the ABA as long as it can say, here is a thing that happened between. So the jury would have to be told something about what kind of events and what kinds of adjustments can be made in virtue of those events. And I don't know, and can you shed any light on what kind of events would permit an adjustment and what kinds of adjustments are allowed? I know for sure you think I know that one half is easier. Fixing an accounting error that's undisputed, you think discovery is an event and you think fixing it is a kind of adjustment that is allowed under this provision. I get that.
Yes,
Where I'm struggling more is, what about, we just have decided that we now have the votes to account differently, and we've decided we would like to. Your view seems to be that's also an event that permits adjustment.
No,
Is that right?
The departure is the event which permits the adjustment. The firm can make a decision to say your ABA, and again, there is no evidence in the record that these were worth a dime.
Well, to make sure,
The firm can
so are
say
you saying if only Ms. Gentner was leaving and she was the critical vote, and once she was leaving, the remaining partners now had the ability to kind of dictate a more favorable accounting handling of the doubtful accounts?
If those
You're saying that wouldn't count as an event. It had to be that there were more of them?
Your Honor, it's not a handling of a doubtful account. It is a doubtful account of no economic value whatsoever that the firm was not able to take into account until these partners left. The fact that there was absolutely no monetary worth, and as you can see by the adjustments which inflated the ABA, yes, I would go to, our case was to go to the jury and say, ladies and gentlemen of the jury, if you agree, please, there was an event. The event was the mass departure. The event was an incorrect financial statement, and we are permitted to make these adjustments.
Again,
I'd
incorrect.
still like an answer to Judge McLeese's question.
Say it again, please.
I'd like an answer to Judge McLeese's question. If Ms. Gentner had been the deciding vote and she had left, would her departure be the event that then allowed the reassessment of the adjustment of the ABA? Yes. Okay, thank you. I think
Your Honor,
we've kept you up at the bench for a while, and I wanted to see if you wanted to make any arguments about your challenge to Rule 5.6.
I'll try to be brief, Your Honor. My client recommended that I not just rely on the briefs, but I would like to say something in that regard. There is a whole encyclopedia of law with respect to restrictive covenants. And it seems to me that it is a question of fact of what is reasonable, what is substantial, what will actually deter an attorney, what will prevent a client from from using a particular attorney in a change. All of this began long ago with the proper statement that lawyers are not tradesmen and clients are not chattel property to be traded or held. I agree with that. But in the modern context, which was discussed clearly in Howard v. Babcock, I understand it's a minority rule. There should be some consideration of the survival of the firm or the economic loss that a firm incurs. And we had the facts here. We had the facts that there was no deterrent to her leaving, witness the fact she left. There was no deterrent to Gentner or any other partner leaving for that matter. There was no deterrent in the amount of money she earned. There was no decline in her income. There was no barrier to clients choosing their lawyer. All that happened was she should be required to let remain in the firm some of the capital to make up for the loss. That's really the question. Can lawyers?
Can I ask you an abstract issue about the question? If I realize there's a question of whether the agreement was unethical, and there's a potentially distinct question about whether it was enforceable, even if unethical. But on the first of those issues, the discussion that you just had seemed to suggest that the way we figure that out is really kind of as applied to Ms. Gentner. And we look at it and we say, well, let's look at all the facts about Ms. Gentner at the moment she left. But the ethical rule isn't focused on that moment in time so much by its terms, it seems to me. The ethical rule says a lawyer shall not participate in offering or making an agreement in which, a partnership agreement that restricts the rights of a lawyer to practice after termination of the relationship. So it seems to focus on the offering or making of the agreement. And so how do you, at the time of the making of the agreement, you're not going to know anything about how it's going to ultimately affect Ms. Gentner or any of the other partners. You could kind of know generally, I guess, about how it might affect partners in the firm. But it seems like the issue as to the ethical nature of the agreement is earlier in time than the moment you're focusing on. Do you have a thought about that?
I think that's probably true with respect to the ethical agreement, but then I'm hard pressed to fit that in with the rule comments which say it has to, if it's a financial penalty or a financial consideration, then it must be substantial. And I don't know how you determine substantiality at the moment of contract.
Well, I
How
think
about
one
the
could.
way that it was done in this case, where the judge said 50% of anything is going to be substantial?
That's, Your Honor, absolutely. And if that's what the Court of Appeals says, if a departing attorney takes $10 million of business from a firm and suffers a loss of 1 cent, okay, ethical violation, unenforceable contract. But that can't be the case.
Why can't it not? I mean, again, I do think it's an interesting question how you figure out if you take the comment as requiring. I mean, the comment isn't quite worded as erecting this as a requirement. But if you take the comment as saying the only in order to be unethical, a partnership agreement of this kind has to impose a substantial financial penalty on a lawyer who competes after leaving the firm. And if you think that the inquiry into whether the agreement is ethical or not needs to be made at the time of the making of the agreement, then for sure that's going to be a somewhat abstract inquiry. But that doesn't make it possible. You would have to look at it and say, well, like, what's the predictable effect on lawyers at the firm who want to leave and compete of an agreement that has this requirement? I don't think that would be impossible. And if you did that, then again, you don't have to get into figuring out, well, what if you had a partner who turned out the partner's ABA was 2 cents, and so that partner would lose a penny? That wouldn't be the inquiry. The inquiry would be, I mean, unless everybody was going to be like that and you could predict that, then you'd say, well, this is never going to be a big deal. Everybody's going to lose a penny. But if some partners might have significant ABAs, and if half of your ABA could well be significant for a number of folks, then one could say at the front end, no, this is an unethical agreement. It's contrary to ethical rules. Considered generally, it imposes a substantial financial penalties on lawyers who compete after leaving the firm. I don't find that an insuperable set of inquiries. Are you suggesting that you think that can't be understood that way? No, I understand. It does get you to a question of enforceability down the road. I get that.
I'm suggesting in this case that where we have the documents and we have the history and we have a perfect understanding of what occurred thereafter, lawyers and law firms are not exempt from the traditional analysis, which is it is a jury question as to whether it's reasonable.
Yeah, but I will say that for somebody who is arguing that a penalty is not substantial, you're working hard to try to recover it. I mean, if it's really not a big deal, just forego it. You know, I mean.
I thank you, Your Honor. For the surviving firm, which struggled mightily because of these departures, it did mean something.
All right. Well, thank you, Mr. Brennan. We've kept you up well past your time, but we will give you a few minutes for rebuttal.
May I make up for a mistake I made? I neglected to tell the court that we have in our virtual courtroom Mr. Harvey B. Jacobson Jr. and Mr. John C. Holman. They've been listening to the argument. Thank you.
Thank you.
We'll hear from Mr. Harvey now. And Mr. Harvey, you are muted. And Mr. Brennan, if you wouldn't mind muting yourself.
No goodness.
You're still muted.
Okay, I think people can hear me.
There you
now.
go.
Thank you.
You're welcome.
May it please the court, and my notes say good morning, but it's now good afternoon. My name is Philip Harvey, and I represent Marcia Gentner. I think as the court has realized that there are really two issues here. I'm getting some feedback from somebody. There are really two issues here. One is, did the Superior Court err in its decision about how the amount of Ms. Gentner's accrual basis account, or ABA, was calculated? And Did the Superior Court err when, having made that determination, it held unenforceable the provision in the amendment to the firm's operating agreement that would slice that number in half, as it says forfeit 50%? I think the answer to both is no. The Superior Court didn't err. It got it right on both times. The calculation, as the court, I think, is aware, the calculation of the accrual basis account starts with paragraph 3 of the 1997 amendment. It provides, as the court has read, the ABA, a partner who has withdrawn shall be determined, shall be that amount set forth in the last annual financial statement for the company, prepared by the company's accountant prior to the date of the withdrawing equity member's notice of withdrawal. That was the year-end, the first year-end 2012 financial statement. And then it says, with adjustments to the withdrawal date, solely for events, adjustments for events occurring in the period between the closing date. Initially, the appellant has made, the firm has made a big argument about that we need to comply with generally accepted accounting principles. That's key here. That's why the documents were changed. But as the court can see, one of the alternatives in this paragraph was that the bookkeeper's annual monthly financial statements could have been the source of this number had the bookkeeper prepared them. The bookkeeper didn't, so we don't have to worry about it. But concerns about GAAP or obsessions about GAAP, GAAP, were not really an issue. Because Ms. Gettner's notice was dated June 17, you look to the statement prepared April 30, 2013, and her ABA on that document was shown to be $141,569.
Can I ask you two factual questions about that report? Do you dispute that that number that you just mentioned reflects an accounting error relating to the failure to take into account firm liabilities by the way of bonuses that were required to be paid? Do you agree that there was an accounting error that is reflected in that calculation?
No, I do not. There was a failure to accrue bonuses that were due to Mr. Jacobson. There had been that same failure to accrue them in 2011. And I don't think there's any evidence in the record that the accountants were told that and then didn't include
Well, I don't mean it. I mean, I guess I said accounting error. You seem to be suggesting that maybe it was an error of garbage in, garbage out. The accountant was
right.
Didn't have the information that was needed. But do you dispute? Let me ask you this way: do you dispute that there was a firm liability relating to those required bonuses?
I do not.
And do you dispute that if an accountant who had been informed of that liability would have been required under general principles of accounting to include that as a liability?
I don't know whether he'd be required to include it, but I don't find anything improper with its conclusion.
I'm not sure I understood. You're saying you don't know whether that would have to be treated as a liability,
right?
As a matter of accounting. But did you dispute that in the trial court? Or in your brief? I wasn't aware you were disputing that. I was just okay.
No, I don't dispute.
You haven't up to this point disputed that there was an accounting that proper accounting on proper information would have included that as a liability that would have reduced the ABA number. Is that right? That you haven't up till right now disputed that?
That is correct, and I do not dispute it now.
Okay, and may I ask you on the other half of it, your opponent argues that it's undisputed with respect to the additional dubious accounts adjustment, that it's undisputed that in fact those were of no value. Is that true? Do you dispute whether those accounts had value?
So we do not dispute it.
I don't think it's relevant, but
I don't dispute it. No, I do not dispute it.
I
think that becomes irrelevant for a couple of reasons I can get to, but no, I don't dispute that. The adjustments, after you look at the number, the 141,000 and change that's in the financial statements for year-end 2012, the adjustments are made solely for events occurring. In the counterclaim filed in this case long ago, the firm said there was one event not two, one event. And the one event was the submission of letters of resignation by 5 other equity members. Those letters were all submitted before Ms. Gentner's withdrawal. All of those other gentlemen ceased being equity members of the firm as of July 30th, the last day of July. Ms. Gentner was ceased as the last day of June. Several of them remained as of counsel or non-equity partners, but they all ceased being equity partners. The firm said in its counterclaim, that's the event. Now, how do you accounting solely for that event? That event, the submission of resignation letters, had no effect, none, zero, on what's a good receivable and what's not a good receivable. What the firm is trying to do is say, that's an event. 5 people or 6 people resigning is an event. Therefore, we can do whatever we want with the financial statements, whether it's in any way connected to that event or not. And that's not what this contract says. The adjustments must be made solely for events occurring. Not if there's an event occurring, you can do whatever you want. It's solely for events occurring.
So it's another way of saying this is that the events have to be backward looking, right? I mean, the submission of resignation letters might signal some alteration of firm income in the future, right? Because these people will not be around to bill.
That's
or
correct.
will not be a lodestone around the firm's neck because they are carrying, they're not carrying their weight.
They're going to be gone, whether that's good, bad, or indifferent.
Exactly. But the event, I think you just said, has to relate to the historic accounts receivable or profits made.
Well, no, the event, first of all, the event has to occur between the closing date of the last financial, which is December 30, 2012, and Ms. Gentner's withdrawal date, June 30, 2013. So what might happen when the other partners are gone in the subsequent months in 2013 and subsequent years is not an event for which you can make an adjustment. The event has to occur some point between December 30 and December 31 and June 30.
Right,
Mr.
but then
Harvey,
what's the nature of the event? As Judge McLeese said, we're not talking about who won the Super Bowl, right? So
Right.
what are the substantive limitations on the event?
Well, does the event, the adjustment has to be solely for the event, solely for on account of the event. So what did that event cause? How did that event cause the firm's finances to change? How did that event change or dictate a change in the financial statement? And the submission of 6 resignations, or 5 plus Ms. Gentner, had no effect on the receivables. As I said, what the firm is trying to do is say the submission of resignations is an event. Therefore, we can do whatever we want with the financial statements because we have an event. But that's not what it means. You account for the events, not use the event as an excuse to do whatever else you want. You have to account for the event. And that's why there's a flaw here, a serious flaw. Once the event occurs, okay, what did the resignations change the firm? It didn't have any effect on the accounts. Therefore, when they go and change the accounts receivable, increase the deduction or the liability, the accrual for bad accounts, they basically double it. It goes from 450 to $1 million. It's got nothing to do with resignations. Now, it's also true that, there was the argument about absurdity, and I won't spend too long on it, but the firm partners knew at the end of 2012, they had receivables that were not being accounted for, not being accrued for, that were not worth much. And they couldn't agree how to do it. So they left them. They left those receivables showing as valid receivables without any set off for doubtful accounts. The reason becomes obvious because if you're going to move down, decrease the right side of the balance sheet, you have to decrease the left side of the balance sheet. So if you write off $550,000 worth of receivables, out of whose accrual basis account are you going to take it? Are you going to take it across the board? Or are you going to take it from the accrual basis account of the gentleman whose bad receivables these were? That's the problem. But that's an inherent problem. So they couldn't resolve that as a firm, so they left it. So the law firm consciously had a financial statement at the end of 2012 that had, they used the term inflated receivables, but had a value assigned to receivables that the firm partners collectively concluded was wrong, but they said, that's okay, we're going to leave it, we're going to go with it. When you do that, there's a risk. You got to live with your financial statement. And then the fact is that what happens when Ms. Gettner resigns and she looks back at the financial statement that paragraph 3 of the amendment says you have to look at, and there's the ABA number. And now Jacobson Holman says, but oh my gosh, that number's too big because the receivables are too big. Well, that's a conscious decision they made. They have a bright line. The bright line was made, the bright line is there. And so you have to live with it. It's not absurd. It's they chose to run a risk that they somehow couldn't have avoided absent dissolution of the firm, I guess.
And Mr. Harvey, I mean, ordinarily, this sounds like we would be getting into issues of fact, but is your point that this is conceded by the firm in this instance?
Yes, I mean, I think
such that summary judgment is still appropriate?
Absolutely. The issue about the receivables being known to be bad, the appellant put it in his brief to this court. I mean, there's no dispute that the partners were acutely aware of this problem. It's just that when there were 8 of them, they couldn't come to an agreement. When 6 were gone and it was just Mr. Jacobson and Mr. Holman, they could do what they wanted to. And they could, just the 2 of them, they could increase those increase the allowance for doubtful accounts and charge it against whatever ABA they wanted, because there was nobody there to stop them. But it's admitted that that the people knew the accounts receivable were not good, were not as good as reflected on the balance sheet. And they made the decision to go forward with it. And that's the definition of a bright line. You live with the choices you make. There's nothing absurd about that. It may be a risk that in hindsight, they wish they hadn't run, but it's certainly not absurd.
So if we then turn to the events language, right? Because another court has looked at these agreements, and that court, a federal district court judge in the Moskowitz case, agreed with you as far as the annual financial report, which report was the operative report, and said, you were right, it's the April 2013 report. The initial report is the report that we're working with, but then we adjust for events. And the trial judge in the Moskowitz case disagreed with you about events.
Yes, it did.
And said that, I'm looking for his language. He said that paragraph 24A, quote, provided the firm with an independent basis for the adjustment to its accounts receivable in the 2012 annual report. Do you understand Judge O'Grady to be invoking the events language, or is he doing something else when he says that there was an independent basis for adjustments?
Well, I think he's doing both, and if I could explain. And frankly, I have enormous respect for the judges in the Eastern District, but here I think Judge O'Grady got part of this wrong. And I also think part of it is that I didn't make the right arguments before him. So let me see if I can do it right the second time. When Judge O'Grady says that you can increase the allowance for doubtful receivables, he was looking to the language of paragraph 24, the last sentence of paragraph 24A, which says, in establishing such accrual basis account, the accountant shall include a reduction for doubtful accounts based upon the prior experience of the partnership. Judge Holman in the Superior Court concluded that all of that paragraph 24A had been superseded by paragraph 3 of the amendment. Judge O'Grady did not. And if you read that opinion, he says that I frankly didn't address that very well. But let me address it now. That last sentence that Judge O'Grady relied upon about accrual basis account, you got to go to the prior sentence. to understand it. It says the prior sentence, and this is in the January 6th, 89 partnership agreement, paragraph 24A, the adjusted accrual basis account of a partner at the date of withdrawal shall be established by the accountants regularly employed by the partnership as soon as practicable after the effective date of such withdrawal, and shall be conclusive and binding upon all partners hereto. That was the old procedure. After the partner left, the accountants could go in and decide what the ABA was. That's no longer the case. The accountants don't get to come in after the fact. You look at the prior financial statement. Then, looking at the next sentence, it refers to in establishing such accrual basis account, which is exactly what the prior sentence tells the accountants to do, establish the accrual basis account after the partner withdraws. The next sentence says, in establishing the accrual basis account, the accountant shall include a reduction for doubtful accounts. That's a process that's described. That's a 2-sentence description of what has to go in, what's part of the process that the accountants would undertake after the partner withdraws.
So succinctly stated, are you saying that both the penultimate and the ultimate sentence of paragraph 24A are superseded by paragraph 3?
Yes.
So my problem with that, or my question about that is, if that is the case, what survives of paragraph 24A? And I ask that because I believe it's in the 1996 agreement. There are certain provisions that say, look, this is what the LLC agreement is replacing. And it lists certain paragraphs and says, these paragraphs are superseded completely. And it doesn't list paragraph 24A. And so it suggests that some part of 24A survives. And then we have paragraph 3 of the 1997 agreement. Maybe it's in the 1997 agreement that says some paragraphs are superseded. I'm confused at this point. But
I'm sorry, Your Honor, I didn't mean to interrupt. I think that the provision you did, the language you described about this operating agreement supersedes some of the provisions. That's in the January 1996 operating agreement. The paragraph 3 that I say replaces in its entirety paragraph 24 is in the amendment to the operating agreement. And it certainly does not say that paragraph 3 replaces paragraph 24A, but I think in substance, that's the only way to look at it, because the accrual basis account is now determined by looking at the last financial statement, then with adjustments solely for events occurring. And it says nothing in that process about giving the accountants some independent reason to establish, to include a reduction of doubtful accounts. And as I think the court, Your Honor, indicated earlier, in that financial statement for year-end 2012, there was a reduction for doubtful accounts. It was $450,000, which reflects on the right side of the balance sheet. But I don't think that, and that's why it's our position that paragraph 24A, those last 2 sentences are both completely withdrawn. That last sentence really has no function. There's no purpose. There's no way to fit it in to a process that involves just looking at the final financial statements from 2012 to determine the accrual basis account and then adjusting for events occurring. There's just no place in that process for letting the accountants meddle around and including reduction for doubtful accounts. Where do they do that? I mean, it's not, there's no place, there's no mechanism for that to work. It just doesn't fit.
Counsel, can I ask you, moving on to the last big piece of the case, the rule 5.6 client migration penalty, or whatever you want to call it. Can you shed light on the topic I was raising in a question I was asking of your opponent about kind of what level of generality and what time we look at these agreements to determine whether they're inconsistent with the rule? Do you agree that in figuring out whether the agreement was invalid, we look at it at the time it was entered into and try to kind of figure out in advance whether the provision at issue is likely to have a substantial effect or sufficiently likely to have a substantial monetary penalty for people who compete?
Yes, Your Honor. It's in fact, I've read lots of cases about this, and I don't think any of the cases that I can recall anyway articulate the issue that you raise, which is the nature of the rule suggests that the contract is improper at the time of formation, and that what happens ultimately in the event of performance or non-performance or whatever, how relevant is that? I think the cases all talk about the actual economic effects upon the partner when the partner withdraws. They don't go back and review and talk about what could have reasonably been anticipated or what the language said at the time the contract was signed, which is probably.
But I thought you said, I was a little unclear because you said yes, and then you said some more things. So I wasn't 100% sure whether you were being polite in answering my question or whether you were answering it yes, meaning you agree though, notwithstanding what you then later said, that in determining whether this agreement was unlawful, we should look at the situation at the time of it was entered into.
Yes.
Do you agree or not agree? You do.
I do agree. I also think you should look at what happens in the event to confirm or disconfirm or undermine whether that conclusion was right. And
well, part of the reason I asked you the first question, though, I sorry to interrupt, but I just to kind of raise a topic. It seems if that's the right inquiry, that all of the partners who signed that partnership agreement acted unethically in making it.
That's right.
Including your client. Including your client.
There's no way to get around that. In every case in which this issue is addressed, every partner who seeks to have a penalty for competition clause stricken has to deal with the fact that they have agreed to enter into and have entered into a contract which violates the disciplinary rule. That's right. I'd like to be able to say I've got some slick answer to that, but I don't. Everybody, if that contract is void, and we think it is, that provision is void because it violates 5.6, everybody who signed it violated 5.6. Having been a partner in a big law firm, I'm familiar with the issues. But that's something I have to live with. But what I can say.
And I take it, is it correct though that your opponent hasn't argued that your client has kind of unclean hands to object to this provision because your client signed onto it and maybe was the prior beneficiary of it? I mean, for all we know, this penalty has been imposed on other departing partners to the benefit of your client. We don't know one way or another, but that could have been, right?
Yes, that could have been. The answer to your question is no, I don't believe, and Mr. Brennan can correct me if I'm wrong, I'm certain, but I don't believe he has ever argued, and certainly not in the briefs to this court, that that unclean hands on behalf of my client preclude her from making the arguments that are made today. And I should say that essentially no case that I've read where the penalty for competition clause is at issue in a law firm partnership agreement has any court ever said, well, we're going to leave it be because you're all equally at fault.
Can I ask you a related question just to make sure what is or isn't argued? If we assume for a moment that the agreement was unethical at the time it was made, and we assume for a moment that provision in the partnership agreement was unenforceable. I mean, there's a question in contract law that can arise if a contract has an unenforceable term about whether you enforce the rest of the contract or what you do. I take it that no one has raised any issues relating to that, and the assumption has been that if this provision is unethical and it is unenforceable, it could be kind of stricken from the rest of the partnership agreement, which otherwise would be enforced. Is that right?
Yes. Yeah, I think Mr. Brennan and I have both operated under the assumption that this particular provision is severable and it doesn't cause the entire structure of 3 agreements to crumble. And
just lastly, from my perspective, I don't mean from the perspective of others, of course, but the question of whether the rule, if it is true that the question of whether the agreement violates the rule is somewhat abstract and is an inquiry that relates to the situation at the time of it's being made or being offered even earlier. that does at least raise a question about whether the agreements which have that abstract form are just categorically unenforceable, no matter what the later circumstances are, or whether if you're getting into the issue of enforcement of that provision in a partnership agreement, there is a need to be somewhat more concrete about the situation that exists as of the time of the effort to enforce that contractual provision relative to or as between a departing partner or departing lawyer in a firm. But is it your view that really the logic of this, of the idea that maybe the inquiry is abstract and at the front end means that the enforceability question is the same, meaning really in figuring out whether this is enforceable, this provision is enforceable, same inquiry, you look at the beginning, you see if it's unethical at the beginning, and it doesn't really matter any of the practical details. Is that your view, or do you think that it's possible that the enforceability inquiry would be later and more concrete?
No, I think actually, Your Honor, you have to look at both. Because with the first provision, at the beginning, upon execution, I'm sure that there are some agreements where you can say, no doubt, this violates the rule. If there's a geographic restriction, or if there's a time restriction where you can't practice law for a period of years after you leave, or you can't practice law in the Mid-Atlantic, that would be obvious on its face. It would strike me. When you have, or if there's one that says the financial penalty, you have to pay the firm X dollars, like $1 million, that would obviously be a problem from the beginning. When you have a case where the penalty is a financial penalty and it's based on a formula or based on subsequent events, and I think you have with a 50% forfeiture, and the firm, bless its heart, used the word forfeiture in the contract. I think the 50% forfeiture, as the judge said, should be enough. Now, if you want to continue.
Well, let me just let me make sure. So your opponent's hypothetical. Imagine that the way things had worked out here, your client's ABA had been 2 cents, and so the effect of this penalty would be to reduce her, payment, her payout on departure from 2 cents to 1 cent. Are you saying that would be enforceable? Because really not. That's not substantial. Or do you think actually 50% of anything, no matter how small, is substantial? But in any event, you think, and I'm curious about your answer to that hypothetical.
No, I couldn't say with a straight face that the reduction from 2% to 1% is more than, it's trivial. And the commentary to the rule talks about that a substantial penalty or substantial amount of money may be a violation of the rule. No,
the one thing I'd say abstractly about those two answers is it does then divorce the unethical nature of the agreement and its enforceability. Because I think in your answers to the questions have been, an agreement like that is unethical outright at the time it is made. And it doesn't, I don't think, it's really not unethical to enforce it. What's unethical is participating in the offering or making of it. So enforcing it isn't really separately unethical. And so, but you have said that an agreement that is unethical when made can be enforced if at the end of the day, practically speaking, it doesn't end up imposing a substantial penalty with respect to the partner who's departing. Those seem to be your answers, which do seem to mean it's not a per se rule that an unethical agreement in this area is unenforceable.
No, Your Honor, I think if I could try to make myself a little clearer, if the difference ultimately ends up being 1 cent, I don't think the agreement is unethical.
Now you've lost me, because I thought you said the right way of looking at whether the agreement was unethical was at the front end when people entered into it.
Yes, I did. What I think I said was that when you're looking at whether agreement's unethical, when you're dealing with a financial penalty or it's created by a formula, you have to look both at the beginning and the end.
Okay, again,
Isn't the answer though that, you look at the penalty up front to see in the abstract, is it 50%? Is there a geographic restriction of, any size? And then you decide if it's unethical. And my understanding was, at least in the context of lawyers, the determination that this is unethical is synonymous with a determination that it's against public policy and thus a restrictive covenant that cannot be enforced in court. Now, if it's only going to result in a payment of 2 cents, no one is going to litigate that. That's just not going to happen. So, I think it ends up being a moot point, but I think you do look up front at the whether it's ethical, and that folds into whether or not it's an enforceable restrictive covenant, at least for lawyers, right? And maybe we have different rules for doctors and dentists, and maybe that's inconsistent, and maybe we should have we should be looking more carefully at restrictive covenants against these other professionals. But at least for lawyers, we seem to think that the lawyer-client relationship is an important one, and that people should be free to continue to work with their lawyer. And we don't like these restrictive covenants under Rule 5.6.
Yes, I agree. I see I've run about a half an hour. Unless the court has further questions.
I think the bench takes a little bit of
Yeah,
responsibility.
not without help.
So thank you very much for your argument. We're going to hear again from Mr. Brennan. And Mr. Brennan, if you could keep it to just a few minutes, although I'm sure you would like to wrap up. And you are muted at the moment.
I think I'm on now.
Yes.
A couple of brief observations. Let me start with Judge East.
And I'm sorry, Mr. Harvey, could you mute? Because I think it just, the more people who are muted, the less the feedback we get.
The more Judge Easterly, you made a comment that that ab initio at the beginning you could analyze and say it's against public policy. One of the things that the trial court refused was us to permit the testimony of Jim Jones as an expert witness, highly qualified, who would have said there is that to determine, not unlike other restrictive covenants, to determine whether it is void as a matter against public policy, you must look to the public. There's no effect on the public here. I think Judge Holman thought, okay, you guys are trying to have this lawyer just recite the law. It wasn't really that at all. The second part of the analysis was reasonableness, which I think is always the touchstone, even for us sacrosanct lawyers. Is it reasonable? And that's a fact determination that the court entirely avoided. There was, Mr. Harvey and I get along very well. We argue and everything else, but I would like to say there is no question that somehow the problem was who the write-off of the ABA would be given to. Every partner has a percentage in the firm. A reduction in the write-offs, a reduction in the receivables by a write-off would affect everybody exactly according to their percentage interest in the firm.
Can I ask you, do you want to say something about your opponent's emphasis on the word "for" in the phrase allowing for adjustments for events? Because your opponent's argument is the adjustment, there has to be an event that requires an accounting adjustment, a spreadsheet adjustment, and that's all you're allowed to do. And you can't just sort of say, here's an event, and now that there is an event, we have a fair bit of latitude in what kinds of adjustments we make. That there has to be a close accounting type relationship between the event and the adjustment that responds to that event, rather than is simply, takes advantage of that event to make a, not tightly adjusted related adjustment.
I think that's a jury question. The documents don't make that clear. The documents don't say only this limited thing. I'd also note that clearly the mistaken financial statement, which failed to accrue, this is an accrual basis law firm. So it's clearly a bad financial statement to fail to have accrued that amount. I agree. Mr. Harvey wants to say only if you lost that pack of pencils, during the time frame, can you adjust that? I don't think that's what the contract says. It says for events, if the event is a mass departure that threatens the destruction of the firm, I can argue to a jury, and should have been able to, that that's a huge event, and the way we can adjust that, or the way we can adapt to it, is by looking at the liability the surviving firm has for these accrual basis accounts.
Thank you very much, Mr. Brennan. Thank
I
you,
al-
Mr. Harvey.
I only wish the agreement had said that when the Washington football team beats the unbeaten Steelers, then the result is X.
Understood. Thank you very much to both for your argument. Thank you for fielding our many questions and for your stamina into this afternoon. The case will be submitted and this court stands adjourned.
Thank you.
Thank you. I appreciate all the questions. Appreciate the work.
This honorable court is now adjourned.